For hearing tomorrow or extension of interim order by
It will appear tomorrow. Extension of interim order.
119.
Matter which I mentioned before, Lordship. Yeah, JC. The matter.
For hearing tomorrow or extension.
It was hot. I'm very. The state for filing that expired from before petition.
From where is this sound coming? I can recall, but then let me find it.
With regard to item 923, your lordship kindly remember before vacation I mentioned this matter, and your lordship has been pleased to ask me to mention after vacation. But this is a mutation matter, solid matter. 923 of the company. No, motions. Okay. Let it.
Yes.
Item number 9.
Give the numbers. Give the numbers. Give the numbers, please. Yes, non-prosecution. Non-prosecution. Non-prosecution.
May I be permitted to mention, my lord? Before vacation, my lord, I mentioned before your lordship directed to mention it after vacation.
The hearing matter.
My lord? No.
Hearing
New motion.
Give the numbers.
My lord, in regard to
Upgradation.
Hearing matter. Group 1. Give the group 1 hearing.
Your lordship.
Is it running in the list? Give the number.
my lord, in regard to
My lord, this matter was moved in acceptance. Interim order is going to be expired on 12.
On?
12.
Your lordship, I am mentioning item number 817 of the combined monthly list. My lord, I am mentioning for upgradation on the ground of urgency. This is a tender issue, my lord. I have been selected as the highest bidder, but my lord, when I gone there, it is with regard to a Jalkor. My lord, when I gone there, my lord, I found that the Jalkor, the measurement of Jalkor is not with regard to the my lord that was floated in the tender. My lord, I am paying the rent, but my lord, without enjoying the entire Jalkor, my lord. I am mentioning
The number.
my lord, in regard to item number 669 of the today list, my lord, in front of my residence, private restaurant has constructed the building by acquiring the government land. My lord, in case and exit stop.
Give the
669 for upgradation.
This is into the daily list.
My lord, praying for upgradation, my lord. 669. 669. I'm teaching.
Constructed a shop over the public land. Despite my representative, no action has been taken.
Give the number. Supplementary list matters will not be upgraded. Let me make it very clear, because the entire monthly list is coming into the supplementary list. So next, I will not upgrade supplementary list matters under any circumstance. Yes. How do you explain the delay?
The last matter, they are thinking 9/12 or 3/22. But I find the application and the report filed by the office of the matter as the
Give the number, let me see. Give the number. I think, please come back tomorrow. Yeah, I've taken sufficient mentions today. It'll appear.
My lord, contempt application. My lord, item number 459.
Contempt application, give the number. How many numbers you are giving?
My lord, only one. Mother file. My lord,
My lord.
file is lying in NRT section, my lord. Requisition may be issued.
My lord, item number 459, I'm paying for the hearing.
I think I've taken more than 50 matters mentioning. If the entire monthly list comes into the supplementary list, how do I deal with the matters? Please come back tomorrow or day after.
My lord, I am paying for 459 item number. No, early hearing, my lord,
What I've said,
motion.
sir. You have heard what I've said. Yes, call the days list, please. And after a couple of days, I'll take up the matters, sir. Allow me to take up matters. It's very difficult if the entire list comes into the supplementary list. Come.
Lord-
Yes.
Lordship.
Days list.
Lordship, here respondent is making construction encroaching the roads of the PW.
Said just now. Yes,
Number
item
one.
one.
My application for contempt, my lord.
An appeal is pending.
Appeal is pending.
It's still pending.
Still pending. They last my before vacation only matter was called, appeal was called on, they was paid for time, my lord. Every day they have paid for time, my lord.
So let it go out of list for the time being. Let the appeal be
My lord,
decided.
last occasion they have come before your lordship, appeal is pending. Appeal is called on, they have paid for time, here they have paid for.
So you have to mention before the appellate forum.
Yes, I have mentioned in the appeal court, my lord.
In view of the order passed on 17th April 2023, let the matter go out of list. Stop, liberty to mention.
No, my lord, your lordship not go out of this, then my lord, they will not move any day, my lord.
Liberty to
Your
mention.
lord, only 7 days time, my
You're
lord.
appearing before the appellate forum.
Also, it was in the list, my lord. My lord, kindly not go out of it.
It cannot run in the list. Yes, next.
Item number 2.
My lord, in this matter, my lord, your lordships may kindly remember, my lord, we made 2 applications in respect of the 2 applications, my lord, for addition of party, my lord. Originally, my lord, it was appearing in the list, my lord.
Contempt application.
No, my lord. No, not in the contempt, in the original application for
petition,
police
yes.
inaction, my lord.
It's my.
And the main matter, my lord, which is pending before lordships, wherein, my lord, interim order was passed by your lordships, my lord. My lord, because we are the interested person, my lord, but we have not been made parties, my lord. We have some grievances. We have to ventilate it before the honorable of this honorable court, my lord. On the last occasion, your lordships were pleased to, my lord, pass the order, my lord. Thereafter, my lord, this appeared before the honorable Justice Joy Sengupta. There, my lord, since, my lord, his lordship was not having any determination, my lord, then, my lord, this matter was, my lord, was directed to go out of the list, my lord. Now it has come up before the lordships, my lord. My lord, originally, my lord, so far as my learned friends matter, my lord, 119 acres, my lord, lease, my lord, 200 acres, my lord, that is vested with the government of West Bengal, my lord. My lord, out of that, my lord, 119 my lord acres of land, my lord, that bill, my lord, that has been, my lord, leased out in favor of my learned friend, my lord. If it is extended, we don't have any objection. We have only,
Application, let him make his
yes,
application.
only objection, my lord.
Lordship,
Contempt is 16 September 20.
yes, your lordship. The difficulty is, as my friend has said, there are more than 500 acres of land over there. Well, it's a water body, out of which 119 has been allotted to me. This matter went before the division bench, and division bench has directed the state and the officer in charge to ensure that I can do pisciculture over there, which I'm not being able to do. The difficulty is now the state is saying that they are not being able to demarcate the land. I have nothing to say about this added party application because there is no locus. I don't know if they are actually residing over there or not. That the state has to decide. Because definitely it's a 500 plus acre of land. If your lordship kindly come to the report of the which has been supplied by this concerned
No,
BL.
who is Contemner, alleged contemner.
This is coming for the first time, your lordship.
This is appearing for the first time.
First time.
Let us deal with the contempt application first.
Milord,
Then
Milord,
we'll go back to the main application.
no, Milord, so far as this, Milord, application, which is, Milord, not in respect of that, Milord, it application, Milord, that is 11019 of 2020, Milord. So far as that matter is concerned, no contempt has been, Milord, that is not, does not relate to, Milord, that contempt application.
So this is with regard to the order passed on September 16, 2022.
16.
It is with regard to an interim order. Passed on an interim.
Milord, only, Milord, but our difficulty is this, Milord, 119 acres of, Milord, the bill, Milord, that has been leased out. We don't have any objection, Milord, if the interim order is extended. But what my learned friend's client is doing, Milord, he is, Milord, enjoying the whole, Milord. The state has not come forward to demarcate, which was the order of the Honorable Division Bench.
Application, scope of which is very limited.
No, Milord, I am not, so far a contempt application, I am saying, yeah, so far the,
Contempt application.
Milord, main application is pending, Milord, where interim order has been passed, Milord.
Yes.
Milord, that is, Milord.
Your lordship, the interim order is expert on the 19th. I will prefer extension of that and kindly one document only. Kindly come to page number 50.
Serve and come back. Serve the alleged contemner and come back. It's appearing for the first time.
Yes, it's happening for the first time.
So please serve and come back.
And Milord, so far addition of party, Milord, in respect of the pending writ application.
When I take up the writ petition, I'll consider your
My
application.
lord.
Have you served the others?
Yes, yes, my lord. All, everybody has been, my learned friend and the state. Also.
আর contempt application এই applicants এটা দেবেন না contempt addition of party চলে এসেছে না আপনার
একটা অর্ডার দিয়েছেন আমাদের
petition action করতে হবে এটা দিন
হয়ে গেল তো 119 সম্বন্ধে আমার কোনো অবজেকশন হ্যাঁ সেটাই বলছি আমি
The applicant petitioner is directed to serve copy of the contempt application along with annexure thereto upon the alleged contemner and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading. 20th June.
And my lord, addition of party may be also considered on that day, my lord, because
Applications.
my lord, so yes, my lord, that
When we go back to the writ petition, I'll definitely consider your application
My
before
lord.
I deal with anything else.
my lord, yes, my lord.
Obliged, your lordship.
I'm with you. Deep.
Yes.
Item number 4.
Matter I am appearing for the petition. Last occasion, my lordship, on 11th January 2023. Kindly see the order.
Who is appearing for the state?
My learned is appearing for the state regarding the payment of compensation. Land has been acquired by the irrigation department, and irrigation department has shifted to the
The state
education
says
department.
that it has been paid to the erstwhile owners. Where are your documents?
That is.
They have come after the 80 years, after 80 years, but they have not come out. The land has been acquired for 80 years. We have tried our level-based personal lawsuit direction, my lord. The no copy of the land acquisition regarding payment is with the special land acquisition officer. That is why, my lord, they have wrote a letter to the requiring body, my lord.
No payment has been made. Why shall I come before this?
Land acquired 80 years
I
ago,
came to learn from the 2012. Mr. Abdul Sattar came to know on 15th May 2012, and through the irrigation department at the time of LR appeal before the spending was that pending before the learned SDLLR. No requisition or no acquisition, acquisition.
You are a
Notice as
you are a
Yes,
substitute
substitute.
purchase.
no, I am not. I am the legal heirs of the, my lord, the Javed Ali Mullah. Javed Ali Mullah's father's name, Dukho Mullah. That expired on 61, Dukho Mullah's sons, Javed Ali Mullah, expired on 2019, and my son, Abu Bakr. My lord, and that is the Abu Bakr's son, Mr. Muhammad Abdul Sattar. Here is the petitioner. And my Javed Ali Mullah has gifted the property by Hebabil Waj in the year of 2008 on 29th January. And Javed Ali Mullah, my lord, expired on 13th February 2009. And the Abu Bakr came to learn from the office of the irrigation department in the year of 2012 on 15th May 2012. To the LR appeal was filed before the SDLR. And against that, my lord, I came before the LRTT. LRTT, my lord, they wrote a letter to the department concerned, SDLR department to inquire and they pay the compensation. And against that, non-payment of compensation, I came before this honorable court. It is the third time before this honorable court. Among no notice in respect of the acquisition or requisition was served upon me and my predecessor also.
After 8 years, they cannot raise this
No
question.
compensation.
You
They
also
have-
the last
my lord,
one,
they
you also
file-
only directed me to produce the
live
record
before
regarding
this
payment,
department.
only
They can-
payment.
If my predecessor has accepted the compensation,
So why
I am
they-
out of the court.
Why is
They have
this
not
come
proven it.
earlier?
They have,
After 80 years, the legal years is
whatever it
coming
may
for your lordship.
that is
kindly
the
appreciate
records are lying there. They have not given the notice. And they have shifted the property to the education department. They cannot do that. Education department has
Why
shifted
they
the
have
property
not
to the
come earlier,
education
my lord?
department. And the land, my lord, the college has been set up in my land. Let them show. Notice has been served my predecessor. Let them show. No copy has been served.
You have referred to section 4, section 6
Yes.
notices.
Yes.
How did you refer to the notices when the
Yes.
notices are not there with you?
No, record, I have the last question. Can you see the earlier report mine?
My predecessor.
My lord, earlier report I have but submitted, my lord.
Yes.
15th of December 2022, my report. Yeah, we have annexed the Gazette notification of 1941.
No notice has been served. Mere notification. No chart of the scheduled land, Khotian, Dag number, and in which portion has been vested, Moja, Dag number. Only notification. General notification. No documents has been shown. And my record was in the favor of my predecessor.
Well, earlier, can you see
When
that
I
my-
came to learn from the SDLR office that my land.
Number 92,
This one?
district 24 Parganas, the Dag number, Patian number, jail
Yes.
number.
No,
My lord, kindly see my lord, report of 28th of March 2023, my lord, I have submitted my.
Yes.
These report I have annexed, my lord. The notification has been annexed. Thereafter, my lord.
and that is the,
Let him complete, sir.
yes. Sorry.
My lord, page my lord 13, 12 and 13, my lord, of the report of 28th of March 2023. Entire, my lord, matter has been considered by the SDLR of Baruipur, my lord,
Page number 13.
12, 13, my lord, is order sheet, my lord.
Yes.
And my lord, the respondent submitted photocopy of the notification as a 4 of Act 18 or 1940, and thereafter declaration as 6 of the Act, published in the Gazette Extraordinary, which may be part of the proceedings.
Yes, but where is the description of the land in the notification? Notification is annexure 1.
Yes. Description law is not there, my lord.
Yes.
Description is land is not there, my lord. The entire,
Three is all right. 4.27 acres.
the entire matter is earlier considered.
As per the order of the LRTT, kindly see the SDLRO on 6/8/2014, not before that. Kindly see the order sheet passed by the SDLRO. As per the, I moved this application, West Bengal Land Reforms Tenancy Tribunal, and Tenancy Tribunal issued the order, direction passed by the SDLRO, as my lord, on 66th August 2014.
That is with regard to
They are
their
status
recording their
report,
name.
page 8. Not before that.
This is with regard to recording
Yes,
the.
Record, yes, my lord, on the basis of no notice has been served upon my predecessor. In the general notification, no Moja, no Dagnama, no Kotian number. They have not shown.
But why
Only
they have
saying
come
that the
after?
1941,
if
that is the land acquired.
If that has not,
Have you challenged this order of the SDLRO?
SDLRO, yes, I have, no, I have not challenged, only my lord, to pay the compensation. I have not challenged the requisition bad or legal or illegal, whatever it may be. I only, my lord, pay the compensation. That the college has been set up. I don't disturb, my lord, only want to compensation, my lord, in respect of the land.
Mr. Potopal, when
Only.
you say compensation has
Only
already
that.
been paid, you have to show documents.
but, at our best effort, Malar, we could not produce Malar because this is not available with the Malar, office of the special learning officer.
1942, you say.
Some documents, not all documents. Some documents, whatever we have, we have.
Their documents, they have annexed the
Produced before your
SDLRO order as per the direction passed the LRTT. Kindly see the order, initial order passed by. I moved this application that thereafter, my lord, this passed this order, not before that. And 2009,
It's narrowed down to payment of compensation.
Yes, ma'am.
Yes,
Payment of
only for-
compensation.
It's no longer challenging.
No,
the
no.
Yes, ma'am. Yes,
acquisition.
no.
yes.
See,
no.
show me the documents showing.
No
that-
documents, it's fairly submitted behavior lots and no documents available with the Malar, office of the respondent authority. Sir.
The compensation, that was simple.
Only, my lord, that's my lord.
It's already been paid.
Yes.
You have paid
First necessary order, Malar, we have no Malar documents.
correspondences between the authority and the petitioners.
It is admitted fact and no document.
It's a continuing lapse.
My client has fairly instructed that the college has been set up. I don't disturb, only to pay the compensation. Only pay the compensation. I have not challenged this.
দিয়েছে রিপোর্ট দিয়েছে রিপোর্টে বলে দিয়েছে রিপোর্টে বলে দিয়েছে
You have admitted that there is nothing to show that you have paid compensation.
yes
Yes.
it is admitted fact, my lord. No document after 1941
Please approach the authority with the representation for payment of compensation. They'll verify your status and pay compensation.
I have already submitted the documents. I have already moved this application and again, my lord, thrice I have moved this before this court.
Prior to this, you had challenged acquisition proceedings.
Yeah, before the LRTT, then my lord, the LRTT directed to the SDLRO to proceed in accordance with law. Then now, yes,
Recording.
my instruction, my lord, my instruction goes, my lord, my client has not challenged the requisition or acquisition, only that is the college has been set up and college is running in full swing. That's why only pay the compensation. My client, last,
The authority, they'll verify your identity and then pay.
yes, my lord, that's. And pay the compensation direction maybe.
Written notes submitted on behalf of the respondents is taken on record. Paragraph for learned counsels for questions. Petitioner,
A special land acquisition collected is the competent one.
owner of the plot in question. And challenge the acquisition proceedings in respect of the said plot. Stop. Learned counsel for the petitioner submits, comma, on instructions, comma, that since a college has been established on the plot in question, comma, the petitioner does not intend to challenge the legality and validity of the acquisition as on this. The petitioner claims compensation for such acquisition. Correct. It appears from the notes submitted on behalf of the respondents. It is also submitted on behalf of the respondents that there is no document available with the department to indicate that compensation was paid to the petitioner slash his predecessor for acquisition of the property. Paragraph this court is entitled to that the state respondents are unable to substantiate payment of compensation in respect of the acquired portion of the land in favor of the petitioner slash his predecessor in interest earlier, such compensation be paid to the petitioner upon verification of the identity of the petitioner as well as his right, title and interest in respect of the plot in question. Paragraph, the petition is accordingly disposed of with liberty to the petitioner to file and to submit an application before the concerned.
Comprehensive representation or application.
Submit a comprehensive application along with relevant documents.
Yes,
In
in detail.
support of his claim before the.
Special land acquisition collector.
He is a party to inherit.
Special land acquisition.
No. The second respondent?
Yes.
Second will be directed one. Yes,
Second
yes.
respondent? Before the second respondent,
Respondent number 2, land acquisition.
Yes.
collector. Yes.
within 7 days,
Within 10 days, ma'am.
within 10 days from date, stop, the second respondent is directed to consider and dispose of the application within 1 month
But this way old matter, my lord, and it's sometimes.
from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, and taking into consideration the documents placed by the petitioner as well as submission made by him, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, in the event the petitioner is found entitled to compensation, such compensation be disbursed in his favor within 1 month
Yes, ma'am.
from the, within 1 month thereafter. Disposed of?
Yep, yep, yes.
Months, 7 days and 1 month.
Yes. 10 days, my lord, and within 2 months and thereafter within 1 month. Comprehensive represent 10 days, ma'am.
Make clear that this court has not gone into the merits.
Yes.
And the concerned authority shall be at liberty to the application made by the petitioner independently and without being influenced by any observation which may have been.
Yes.
Number 5.
Yeah, please, Your Lordship, my lord, I'm for the petitioner in this matter. I'll be seeking your 4 weeks time, further time, Your Lordship, for using an exception to the report that's being filed by the state.
Respondents.
The state respondents, my learned friend is appearing, and the board is there, electricity board.
Mr. Mahanta is appearing.
Yes, Lordship. Has happened, yes. Janshad. They had used a report, but we could not do it because we sought for certain documents from the.
Wait.
Yes.
Learned counsel for the petitioner seeks extension of time to use an exception to the report in the form of affidavit submitted on behalf of the respondents. paragraph, let the matter appear under the same heading on 7 July.
Yes, Lordship. Right, Your Lordship.
Number 6.
My lord, I am appearing for the petition in this matter.
For the National Highway Authority.
My lord, in this matter, the matter is regarding acquisition of land and subsequently disbursement of compensation. My lord, the petitioners were granted compensation in terms of the National Highways Act. And thereafter, the petitioners also made representation to the effect which is appearing at page 45. Page 45.
You're aggrieved with the amount of compensation given to you.
Not only amount, my lord, I am praying compensation to be awarded in terms of the Act of 2013. Fair Compensation Act.
Page.
Page 45, my lord. Annexure P7.
Is it a 3G5 application?
My lord,
This after
after arbitration.
After arbitration?
My lord, kindly see page 44. One of the payment vouchers will be appearing. It is payment notice for ad hoc award under section 3H under NH Act.
You aggrieved by the arbitral award.
Yes, my lord. No award has been served on the petitioners as of yet. But I have no
How did
option.
you file this application then?
Well, I filed because I made a representation for compensation under the payment of fair compensation act under 2013.
Arbitral award was passed in your presence.
But no award has been communicated. The work is going on. Everything is going on. Everything has been utilized, my lord. I am aggrieved by that, my lord.
You have your recourse under section 34.
My lord.
You have your recourse.
Yes, my
under
lord.
section
My lord,
34.
that section 34 recourse starts only when I have got a copy of the award, my lord.
You have
Unless
not
and until.
furnished a copy of the award.
That is something that the state will be able to say. Insofar
Mr.
as the
Mahato,
annexure,
the state. He was here just now.
On the last occasion, he did appear.
Mr. Mahato,
He was here just now. Where is he?
He's there.
Yes, Mr. Mahato.
My lord.
You are appearing for the state in this matter.
এটাতে আপনি ছিলেন আগে বললেন উৎপল সরকার পরপর দুটো থেকে এই তো এই দিকটাই তো
Lordship, they have also received the enhanced compensation annexure P6. Those are the receipts. It starts from, your Lordship will see page number
That is
42.
after arbitration.
After arbitration, the enhanced amount has also been
I think
received.
his primary grievances, he has not received a copy of the award.
Absolutely.
unless award has been served, the limitation does not run. That is the settled law. Unless award is served, I cannot challenge that, my lord. But since I have
I
applied,
think Mr. Mahato will be able to apprise us. Yes.
My lord, actually the award, according to the statement of the petitioner, the award has already been, arbitration award has already been passed.
Has already been?
Passed.
may have been, my lord, but
No, no. Have you
but-
served a copy of the award? That is the law.
My lord, there is no averment that he has not received. In the writ
Please
petition.
show me a document that you have served
My
the
lord,
copy, Mr. Mahato.
My lord, it is the case of the petitioner. He has made a statement that award has been passed without giving him opportunity of hearing. Kindly keep, come to page paragraph number 16. Page 10.
He has not said that he was not heard.
My lord,
Where is it stated that it was passed without hearing him? He is aggrieved by the award, by the compensation.
Yes,
determined.
the amount of the compensation.
the apparent passed an award, but the order passed and approved by the authority is nowhere in the vicinity of the, that is another thing that can be, he can prefer an appeal under section of.
He can prefer an appeal when you have served a copy of the award. Have you done that, sir?
There is no averment that he had made an application for the award that
Well,
he has not.
I am not,
received.
Does-
I am not
does he
supposed to
have
make
to-
an application.
Is that the law?
My lord,
Does the law require him to make an application for receiving a copy of the award?
that is not, but he, his knowledge
My lord.
is there. The award has been passed.
My lord,
Is
with
that sufficient, sir? Can you bypass the law with that?
My lord,
Mr. Mahato, please show me a document that you have served a copy of the award.
My lord,
That solves the entire issue.
may I submit one thing? My lord, I understand from where my learned senior friend is coming. My lord, this matter can be disposed of with a direction that they served me a copy of the award. My lord, kindly seize the payment vouchers are there. That shows purportedly an award has been passed. I have not received it. My lord, it will be a time-taking process if they are to ascertain whether it has been served or not.
Did you receive the payment when the copy of award was not
Well,
served? upon you?
Payment vouchers were issued to me, but not the award. My lord,
You have received payment.
there have been several other cases, my lord, where award has not been served, but these vouchers have been served with to the parties. This is not even the next item appearing, my lord, is similar.
One thing which can be seen is whether they have received this amount with objection. Under
Well,
objection or
So
not.
that's separate
Well,
issue. altogether.
paragraph
This
20
will not deal with it.
Well, paragraph 22, I have stated, I have even received the payment vouchers under objection. Paragraph 22, page 13, my lord. I cannot show such endorsement, but such endorsement will be with the respondent authorities. Paragraph 22, I have stated, towards the bottom of the page 13.
Lordship, let there
And
be a
the payment
direction.
notices were served on you.
Yes, my lord, that is, I have annexed that. I have
Have
annexed.
received
Not
the
the
payment.
copy of award. That
No,
should
ma'am.
have been served.
My lord,
Lordship, let there be a direction
So
upon
where-
the state.
payment voucher. Payment voucher has been received.
I have awarded
Not
that.
the copy of award,
Award,
sir.
award.
But not the-
They are different.
Well, but where is the statement that he has not received the copy of the award? Where is
My
the
lord,
statement?
I am not supposed to make an application to get a copy of the
you have
award.
That copy. It
I-
is not, but you have, there must be a statement that that he has
Then-
not received the copy of
My
the
lord,
award.
if that is the
There
submission
must
of my learned senior friend, then I beseech your lordship to consider the present writ petition for enhancement of compensation under Right of Fair Compensation Act of
The
2013, my
award
lord.
has been passed.
Award has been passed, let that be, since my learned friend is saying,
Prayer C says that immediately upon publication of such award,
Yes,
he has asked for the same.
yes,
Prayer C, last part.
my lord.
page 20.
But unless the award is, my lord, he has challenged the award. And the
He
award.
cannot
not only
challenge the award before this
Award
court.
has been challenged. Award has been challenged before the arbitrator. Award has been challenged.
That part is over.
That part is over. Then after that part is only the remedy, the appeal under arbitration. Act.
Upon receipt of arbitral award,
But
where
after,
is that document?
but is there any statement that he has not received the copy of the award?
No statement is required. The court asks you, have you served a copy of the award, which is mandatory under the law?
My lord, I have to take instruction for.
Irrespective of any statement made by the petitioner.
My lord, that is the prima facie cause of action. The prima facie cause of action that.
Because you have not served a copy, he has challenged the award before this
My lord,
court.
without any averment, that is the only mere presumption.
He has challenged the award before this court because he has not received a copy.
He has not challenged the award. Where is the challenge the award?
What is the prayer, Mr. Mahato?
My lord, the award has not been challenged. Arbitration award has not been challenged.
Because he has not received a copy, how can he challenge?
But payment vouchers are given. The vouchers have been annexed.
You are aware that the voucher and the award are not the same thing.
Not the same thing. But he is aware.
Will you serve a copy of the award to him or have to give necessary directions?
Well, let the we shall serve him copy the award and he will take the appropriate step. in
Yes, my lord.
accordance with law.
That is what I propose, my lords.
Heard learned counsels for the parties. Paragraph. It is submitted on behalf of the petitioner that being aggrieved by the award, being aggrieved by the compensation granted to him for acquisition of his land, comma. He filed an application under section 3, capital G within bracket 5 of the National Highways Act 1956 before the learned arbitrator. And upon arbitrator stop the and upon the petitioner the petitioners received payment notice of ad hoc award under section 3 capital H of the Act of 1956. But no copy of the arbitral award was served upon them. Stop. The petitioners seek a direction upon the state respondents to serve a copy of the arbitral award
If
upon
not
them,
already served.
comma, if not already served, comma, in order to enable them to approach the appropriate forum under section 34 of the Arbitration and Conciliation Act. That's your prayer. Paragraph. Learned counsel for the state respondents is unable to apprise the court as to whether copy of the award arbitral award has already been served upon the respondents, upon the petitioners. Paragraph. In view of the above, the writ petition is disposed of, directing the.
That's my number 4, sir.
Who should be the authority?
ADMLA.
The
That's
district
my number
judges?
3, my lord.
3.
3. As well
The
as
third respondent to furnish a copy of the arbitral award upon the petitioners, comma, if not already furnished, comma, within 7 days, Mr. Mahato?
10 days, my lord.
Within 10 days from the date of communication of this order.
my lord, website copy of the order.
This
Website copy
thing
of
get
the
it by tomorrow.
my lord. Grateful.
Disposed of. Exactly.
Obliged, Lord.
Number 7.
Similar matter.
I am
Your
appearing for the
Lordship.
petitioner, my lord.
Similar.
Yes, sir.
Similar matter, my lord. Same direction may be passed.
Bashu, same. Here you say that no arbitration proceeding was initiated.
My lord,
Paragraph 12.
I apologize, my lord. I apologize. In this matter, it is a little different. In
Hmm.
this matter, arbitration proceeding to the knowledge of the petitioners was not initiated. That's why I made an application that under 3G5, it may be considered in conjunction with the new act.
Where is
2000.
your application?
My lord.
937.
Page 57.
Alada. Page 57.
This is under Right to Information Act. And
Where is your application?
my lord. The information was not given. That's why no further application was made. This is the only application they made.
Petition doesn't lie.
My lord,
You have an appellate for provision if information is.
my
not
lord, in this
given.
matter, may I submit one thing, my lord? After getting the notices for compensation, the my lord, I apologize, my lord. My lord, kindly then give me liberty to make an application so that,
Liberty is not necessary. The law
Yes,
gives you the
madam.
liberty.
but
You can only withdraw. You don't need liberty for 3G5.
yes, my lord, I do not need
3G5
liberty.
itself is sufficient.
Lordship, 3G5, probably your lordship, the arbitration has already taken place, although he was not represented in the arbitration and he was not aware of the arbitration.
So that's a separate cause of
proceedings.
action altogether.
Not sure.
You have to come back with a separate petition in that case. If you're aggrieved,
My lord, since my learned friend is submitting that arbitration has concluded, let the award be because
is that part of
even
your writ petition?
no, my lord, that is not part of my writ petition. But
Sure.
since award has been passed, I am just submitting, even without an application under 3G5, good or bad, whatever it is, my lord, an award has been passed. I have to challenge that, my lord.
No, there are several issues. If you have not been heard at all, you don't need to challenge. You can come before this court.
Yes, my lord. Yes.
If
that
you have
is-
been heard, you have to take a separate recourse. So you cannot deal with that in this writ petition. You can only withdraw.
Let him file a fresh writ petition with that.
Yes.
Yes.
And the cause of action will also not be the same. This has become redundant.
My lord.
Isn't it?
Yes, my lord. My lord,
So I'll just record that you don't want to proceed with this.
my lord, the only problem is, my lord will see from the record, I have taken several adjournments in this matter. I have not been receiving instructions since before the pandemic. That is the problem. I am not in touch with the client. My lord, unilaterally, I
Only
cannot.
For default in that case?
My lord, kindly makes it out of list, my lord, if possible.
No, I will not keep it pending.
Then, my lord, kindly grants me 7 days time. I'll issue a notice to the petitioner, at least one of the petitioners, so that
Please
if
do
they
that.
wish to proceed,
Please let him do that.
My lord.
Yes.
I'm grateful.
As a last chance, the matter is adjourned on prayer of the petitioners. Paragraph, let the matter appear under the same heading on 13 June. Next.
Grateful, my lord.
Right.
Number 8.
I've got the petitioner, my lord.
Yes.
I'm appearing on behalf of the private respondent. 8 and 9.
My lord, this is the unauthorized construction petitioner made.
Who is appearing for the state?
Private.
You are appearing for?
Private respondent.
My lord, my representation starts on page 43, my lord, I said before.
State.
Earlier occasion was, my lord, it was not executed, my lord. Long pending matter, I served. It's completed, my lord. Let the authority control be considered the
Mr. Dey, may I request you? Unauthorized construction.
copy. 62, page 2.
Please give him a copy of the
My
report.
lord, my lord. 62.
Yes, where is your application?
My lord, Annex P4, page 43. STO. 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 Three.
Well, I'm for the private respondent.
This is under the 62 Act.
My lord, 62. Respondent number 3 is the competent authority.
Subdivisional
SDO. Function STO, my lord.
Yes, do you have anything to submit?
No, my lord, let them consider.
Let the representation be considered.
After giving opportunity to hear it.
Yes,
Ah, my
absolutely,
lord.
absolutely. None appears for the state respondents. Paragraph, Mr. Dey is presented for regularized quorum, copy service. Paragraph, the petitioners claim to be the recorded owners of the plot in question and submit that the private respondents have illegally encroached upon government land adjoining the plot of the petitioners, comma, thereby obstructing their egress and ingress. Stop. The petitioners submitted a representation in this regard before the concerned authority on
13 August 2018, my lord, 2018, page 45.
13th August 2018, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the state respondents that the third respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, in accordance with law. Disposed of.
Number 9.
Yes.
Your lordship order, my lord, respondent had filed its report, my lord. My lord, I want to take exceptions to the report.
He is appearing for the Mr.
My lord, the draft is ready, my lord. Petitioner.
You need some more time.
Yes, yes, my lord. I will, by today, my lord, I will affirm.
Learned counsel for the petitioner. National Highways has submitted a report.
Yes. My lord,
Today on the next.
No copy was there.
no. Oh, my lord, I filed my evidence service on the earlier occasion, my lord.
My lord, 11 my learned friend is there, my lord, report is ready, my lord.
স্যার শুধু 10টা
আগে 11টা হয়ে যাক, তারপর 10টা
আপনার সঙ্গে বৈরতা আছে যে আপনাকে কপি দেবো না।
না সত্যি কপি আমার নেই, ঘরে নেই, আমি দেখেছি এটা। একটা ওকে দিয়ে দাও। My lord, your lordship can take 11 first.
Copy. You have to serve a copy to the
Yes, my lord.
others.
Just now I received the copy.
A report in the form of affidavit submitted on behalf of the state
report লাগবে?
respondents is
একই
taken on
report?
record.
তাহলে রিপোর্ট লাগবে।
Stop.
You
Copy
get a
of the
copy now.
report is served upon learned counsel for the petitioner in court this
দিও
day.
না, সত্যি নেই।
Paragraph. On prayer of the petitioner, the matter is adjourned. You want to use an exception? No.
Same report was filed on the early another matter.
Let the matter appear under the same heading on 28th June.
এটা কি আপনি কি আলাদা ইয়ে করবেন দুটো একই?
না, একই। আর তুমি একটা কপি আমাকে দিও।
Written copy?
হ্যাঁ, written copy। 10টা দাও, এক্ষুনি দাও।
20. This is item 11's report, not
Yes,
10.
yes, not 10, not 10.
My lord, 10 my lord, there is any necessity of
The
giving
same
report
thing,
of
my
the
lord,
same
3
thing, my lord.
persons, my lord.
So 10, no report is necessary. Let me record that.
Yes, my lord.
10 এ লিখুন। Learned, 10
He rely upon the report filed by the state.
learned counsel for the state respondents does not intend to submit any report in this matter.
And wanted to rely upon the report filed in WP number item number 11
You
because
want to rely on this
Yes, my lord.
and seeks to rely upon the report in the form of affidavit submitted in WPA 323 of 2019.
আপনি কোন দিন দিন?
Paragraph. Let the matter appear under the same heading on 28th June 28.
and though my lord is not a time, my lord, under compelling circumstances, my lord, the urgent determination of group 8 has been assigned to your lordship.
Yes, yes.
My lord, I have an urgent matter. I went there to mention, but I came to know that for last 7 days, coming 7 days, his lordship will not sit.
What is your urgency?
Urgency is that there is a selection of a site of a in favor granted in favor of a petitioner in the fair price shop. Now, my lord, inspection was held. 2 godowns were there, both belongs to me. Now they are disputing one go down. There it is not title is not clear, but the other go down title is in favor of me, and I have produced all the documents. Without inspecting that same, now they are going to finalize by rejecting my application. I filed an application to reconsider my review my application, considering that I have already offered the both the go downs. If it is, if your opinion that the other go down,
Mentioned in the morning.
morning, my lord, determination is not there, my lord. It has been given just now. That's it.
No, determination is there also. Yes. Determination was there in
So
the website.
then because in the website, my lord, just now it is uploaded.
No. It was there in the website.
Sorry, my lord.
During vacation, it has been given.
I've been, then my lord,
Come back tomorrow.
I'll come back to court. File করা হয়ে গেছে. Sorry, my lord, I beg to be corrected,
Come
my
back.
lord. Because it was uploaded in the website just now.
And let me call the next matter. Same, on the same date.
Same.
11 তে ওইটা করুন, 10 এটা বলেছি, ওটা 11 করুন, হ্যাঁ।
Yes, 11 on a report file.
Same date, 28.
Yes. 10টায় আমার আর অনির্বাণের নাম।
11 same.
I for the petitioner, my lord, in this matter, old matter, yes, notice service is required, my lord, I'm paying for action.
Old matter, 19 matter, yes. There was a direction for fresh service. Yes? You are for the respondent? 8 was appearing on the earlier date also. Since service upon the state respondents is not complete, let the matter stand over till 3rd July.
Number 13.
My lord, I am appearing for the petitioner, my lord. My lord, I have lost my writ petition. Then I have applied for the certified copy long back. Still, my lord, I am not getting the certified copy of the writ petition.
Number 10 in department bolun immediately certified copy jane deয়. Number 10 in. Give the number, please. I'll see. I'll look into it. ডিপার্টমেন্ট কে বলুন ইমিডিয়েটলি সার্টিফাইড কপি না দিলে আমি লিখে পাঠাবো কোর্টে আজকের মধ্যে যেন ইস্যু হয় বলে আই লুক ইনটু ইট
I'm grateful, but unless gone out the file to the department, I won't get the certified copy of the report.
ফাইলটা আজকেই পাঠিয়ে দিন শান্তনু ফাইল আজকে নামিয়ে দিন I'll send it on today itself.
I'm grateful.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 4th July.
4th July, I'm grateful.
File নামিয়ে দিন আজকে Yes, next.
Lordship, in item number 14, Mr. Ujjal Rai is appearing on behalf of the petitioner.
Yes.
He's currently on leg at courtroom number 8. Lordship is humbly praying for not this week.
Several adjournments have been granted earlier also.
Lord, the affidavits have already been exchanged. Lord.
This is a hearing matter.
Lord, it has been exchanged because we have filed our affidavit in opposition.
Is it an affidavit or a report?
Lord, a report in form of an affidavit. Lord, because, but we have,
So it's at the motion stage.
my lord, whatever my lord calls.
Let there be a date.
My lord, we fix up it.
On prayer of the petitioner, the matter is urgent. Please be ready on the next occasion, sir. Several dates have been
Yes,
granted.
Lordship.
Let the matter appear under the same heading on 5th July.
Grateful.
Yes? Mr. Deyas.
Lordship, item number 15, 16, 15, 16, 17 and 18 are similar matters.
Yes.
14 to 18, Lord. All stand
18, 14 to 18.
14 to 18, same order.
3rd of July.
3rd of July.
My lord has fixed it on 3rd of July.
Covenant. 5th of July.
I'm grateful, my lord.
Grateful, Lordship.
Mhm.
18.
14 to 18, same order.
19th.
Lordship, I am appearing on one of the private respondent, my humble plea for a 1 week adjournment.
In 19,
My lord, on repeated occasion, adjournment was made, my lord, unauthorized construction, my lord. Let the authority concerned be considered, my lord.
My lord, this is an usual order. My lord,
Usual
nobody will be prejudiced. My lord has passed so many orders.
what is your difficulty, sir?
Yes,
I have
because
without my brief,
Yes,
without my brief.
except for buying time, what is your difficulty?
On repeated occasions.
আরে এটা তোর কোনো ইয়ে নেই, এটা কোনো হিয়ারিং, yes, my lord, yes, yes,
So let the representation be.
yes,
You'll be given an opportunity of hearing.
yes, already, he has to.
You can
Authority
try
has
and
to
find
give an opportunity,
authority.
yes.
Where is your representation?
My lord, annexed
31,
page
page
31, my lord.
Have you corrected the cause title? You've stated group 9.
Right, ওটা
My,
correct.
leave may be granted, my lord.
Mistake, my lord, it can be corrected.
Please correct the cause
My
title.
lord, here and now.
On prayer of the petitioners, liberty is granted to correct the cause title of the presentation form, the presentation form and the cause title of the writ petition. Paragraph, the petitioners claim to be the recorded owners of the plot in question and submit that the private respondents have illegally encroached upon government land adjoining their plot, thereby obstructing their egress and ingress. Stop the petitioners submitted a
My lord, this is
representation-
only, my lord, 1962.
62 Act and yes,
Subdivisional,
SDU. The petitioners submitted a representation in this regard before the concerned authority on
27/6.
27 June 2019, which is yet to be considered. Stop the petitioners, pray for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the fourth respondent,
My lord,
it is governed by the, my lord,
62
West
Act.
Bengal unauthorized, no,
eviction of
eviction of unauthorized occupancy act 1960.
Public land, public.
the fourth respondent be directed to
Public
consider the representation in
land.
accordance with law. Paragraph.
SDU is the competent authority.
In view of the above, the writ petition is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 3 months
my-
from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, in accordance with law. Disposed of, which are done.
Obliged. My lord, Subirpal is with me. Subirpal, my lord,
He is not with you.
well, he is in code group
number.
number, my lord.
No premium.
Oh, obliged, my lord.
Next,
my lord, I shall correct the cause title
yes,
here and
please
now.
do. The presentation form and the cause title both.
ওইখানে
Number 20.
Yes,
Now, my lord, can you consider the earlier order passed by your lordship on the earlier date? At a glance, my lord. So plot number 733, whether my interest.
you
Yes.
wanted to take instructions, Mr. Roy, on
Yes,
this.
yes, that ground, my lord. If your lordship can turn to page
28,
28,
yes.
9, 10, and 11, my lord, can you consider? My learned friend brought to the notice only the serial number 6.
Six is Shahadev Burman.
Yes, that was mentioned in my lord's order also. My lord, can you consider 9, 10, and 11? Page 28. Same page, my lord.
Ashid Shah, Syed Shah, and Shahadat Shah. Okay.
And for the purpose of this is the record of rights which I got because as my lord was pleased to direct, these are the names of the persons of the petitioners recorded in respect of plot number 733. এটা একটু জজ সাহেবকে দেবেন।
Yes.
Their name also recorded in respect of plot number 733. 3 persons, 3 petitioners are there. Their name also been recorded in the recent record of rights. So, my lord, The plot number 733 is a big plot of land. There's several other parcels are there, but I need not to go into that aspect. Now, the land of the petitioners have been utilized for the purpose of construction of Allahabad. Now, my lord, along with the petitioner, some other parcels also made representation and ultimately filed a writ application before this honorable court. Page 34, my lord, will find the order passed by this honorable court. Where it was page 34. My lord, got it?
Yes.
And it was pursuant to which, my lord, an order was passed, page 41. My lord, can you consider page 41? The order passed by the executive engineer, irrigation division.
Yes.
And there, these lands have been subject matter of utilization that, my lord, will find this is the copy of the sheet which was forwarded by the concerned executive engineer for the purpose of acquisition. My lord will find that there is a report that the initial proposal was made, but it cannot be utilized. Now, according to us, my lord, the plot has been utilized without any compensation. Either they have to take instruction on that aspect, but initially they raised an objection regarding my title. That's why my lord was pleased to direct me to take instruction regarding my relation to plot number 733. My lord will find the plot number 733 is also there in the sheet itself that your lordship will find at page 28. I have drawn to your lordship attention. And page 25 is the forwarding letter. My lord will find page 25, where your lordship will find this was forwarded by the executive engineer to the LA collector for the purpose of initiation of the acquisition proceedings. I am forwarding the land acquisition proposal along the schedule of land, 1 copy tracing cloth and 5 copies of the ammunition prints showing the area of more than less acre acquired permanently for the construction of embankment of the Mauja Kusumtala. Yes, Namkhan urgently required the section of Regional Education Acquisition Act 90 any kind be taken and position delivered to this office as early
So
as.
sometime in 2014.
Yes. It was forwarded, my lord. After that,
After that, nothing has
been done. And the order, my lord, will find from the order itself, it was admitted by the special land acquisition officer that yes, proposal was there, but it has not been
The
materialized.
state needs to take instructions.
Yes, my lord.
Come back with instructions.
Yes. If subject to action, my lord, this is an unauthorized use of the land. So, upon consider joint report.
Let them come back with instructions. Because these documents prima facie show that there was a proposal.
Yes, that's why, my lord, if the joint inspection, if it's found it is not, they have not utilized, then it can be. Otherwise, again, my lord, if they found.
After this joint inspection will also not be required because it is admitted that a ring bath has been constructed there.
To the extent, what extent, my lord, that is the only
Let
thing.
us see what they have to say.
As your lordship, please, my lord. But record that because earlier order, my lord was pleased to express a doubt regarding
Learned
that.
counsel for the petitioners. Submits petitioners takes this quote to page 28 of the writ petition, which demonstrates that portions of the plot in question being plot number 733 is owned by the petitioners. Stop. The petitioners submit that the plots owned by them have been utilized by the state respondents by constructing a ring bath therein, but no step has been taken for acquisition of the same in accordance with law. Stop. Learned counsel refers to page 25 of the writ petition, which indicates that proposal for acquisition of the land under the West Bengal Land within bracket requisition and acquisition within bracket closed Act 1948 was forwarded by the Executive Engineer Kakdeep Irrigation Division to the LA Collector South 24 Parganas by a letter issued on 9th August 2014. Stop. Learned Counsel submits that no further step has been taken by the respondents till date. Paragraph. Learned Counsel for the state respondents seeks to. You want to come back with a report?
Yes, ma'am.
Submit a report in the form of affidavit in this regard. Paragraph. Let the matter appear under the same heading on 5th July.
As your lordship pleases, madam.
Please serve an advance copy, Mr.
Yes.
Natarajan.
Number 21.
I am appearing for the petitioner, my lord.
Draft for the private respondent.
Yes, ছিল তো। Exception পেয়ে গেছে তো।
You wanted to take some instructions in this matter?
Yes, that I want to take instruction to that effect. My lord, I have filed an exception to the report itself. My learned friend has.
I got it, my lord.
Have you filed the exception?
ফাইল করা হয়েছে? দেখ। May I go through, because my copy there is a FAW, it is FAW, but I don't know.
I do not find a copy. Shantanu, dekho.
No, exception. It is something.
Exception.
Private. আমি exception দিয়ে পেয়েছি। কাটুদা exception পেয়েছি গো। এই যে
Exception.
সার্ভিস হয়ে গেছে।
Yes.
Yes. Petition copy পাইছে।
Who is appearing for the private respondent? You are appearing?
উনিশের তো। আমাদের হ্যাঁ petition copy এই যে। এটা কি? এটা তো? এক মিনিট। Your lordship will find initially the acquisition proceedings was initiated against the land which according to the petitioner is also the owner in a portion of the land. Now my lord, kindly consider page 21. That as the land was utilized or taken, possession was taken, so I filed an application under the Right to Information Act, who are the awardees and on the which date the award was declared and the quantum of the award. That your lordship find?
Yes.
ক্ষতিপূরণের নির্ধারিত টাকা পাচ্ছে তাদের নামে কোন কোন প্রমাণপত্রের সাপেক্ষে ক্ষতিপূরণ পাচ্ছেন প্রত্যেকের জজ পেতে চায়। My lord, kindly consider this was filed on 15/2/2019. My lord, got it at the bottom. My lord will find. Now my lord, can turn to page 22. Initial application, after that it has not been answered, second application. Now my lord, can you turn to page 24.
The reply.
The reply. Your lordship will find, with reference to I mentioned, inform you that total compensation of moja such and such, rupees such and such, 133 only. Recipient of the compensation, Shomiran Mundal, Sudhir Mundal, Gauranga Mundal, and Kanonbala Mundal.
Private respondents.
Private respondents. Deed, position, and record. My lord will find. Now, my lord, can you consider page 25. Deepak Mundal Karya, you know?
Yes.
না না ওটা যশাই ইয়ে করেছিলেন যে কবে আমরা ইয়ে দিয়েছি।
Page 25.
Yes, my lord, your lordship will
Yes.
find
25 na 26?
25, P6.
আচ্ছা,
that-
হ্যাঁ, ঠিক আছে।
6 is 26.
P5, my lord.
Yes, P5.
Yes, my lord.
কাননমালা মন্ডল।
কাননবালা মন্ডল, গৌরাঙ্গ মন্ডল, দীনবন্ধু মন্ডল, বড়রাম মন্ডল, সমীরণ মন্ডল, সুধীর মন্ডল. They are all the co-shares instead of the said plot. Now I can turn to page
Your
20.
predecessor is Balaram Mondal.
Yes. 7 decimal. My lord will find 7 decimal.
Yes.
Page 26, my lord. This is an objection which was given on 30th January 2019. I raised my claim regarding for the purpose of compensation. It was a said plot of land. And the representation was made that was not been considered be as it may by the learned advocate. Now, my lord, kindly consider the report. This is the sum and substance of my case, that I am all the co-share of the plot of land. Excepting me, my lord, the award was declared in some other co-sharers by depriving me. I am also entitled to get compensation. Pursuant to which, my lord, a report was filed. My lord, can you consider the report itself?
Yes.
These award, my lord, your lordship will find, were declared on 11th, page 3. My lord, can you consider the chart has been given by the
Yes.
respondent authority, Godango Mondol, area amount award 11/12/2019. And this 13/9/2020, 11/12/2019 and 11/12/2019. That all these after filing up my objection regarding claiming my right over the property in question. Now, my lord, that next paragraph is very important, my lord, paragraph 8. The answering respondent do not admit the validity of the petition and no communication is made by the learned advocate for the petition earlier than 30th 11/2020 and about filing the instant writ petition, being number suggested by Deepak Munda and others. Even no copy of the writ petition reached to his end. The applicant's petition is also given opportunity of hearing and natural justice and explain and such very bad position of the awardees. Even the petitioner has been intimated the status and finding of this regard eligible awardees against his RTA application 5/2/2019. My lord, this award was declared on 11/12/2019. Then the status of the awardee was declared prior to that. I do not know how it can be done. It can be answered by the state respondent in this aspect. Be as it may, my lord, I am going. It was answered on February 2019 when the award was declared in sometime 11/12/2019. Whether it was paid on 2019, I do not know, because it was mentioned that award on 11/12/2020 and 2019. Wherein the particulars of the awardees were mentioned, the petitioners before disbursement of the award never raised any objection on the decision of the department, nor made any claim over the demand, which now they have alleged. They are neither in physical possession at the end of the, nor they remained available at the time of making of such failed inquiry. Hence, the award money was disbursed in to the above for awardees on 11/12/2019 and 39/2020. So there is no question of considering the petition as such related.
How can this anomaly be explained when award was declared on 11 December 2019? The RTI reply says that recipient, the compensation was replies on September. This is September 2019. So how can the award be declared later on and the RTI reply given earlier?
Because even if my lord taking to all.
So on the date of RTI and the reply also there was no award.
According to
According to
their
the state,
report.
yes.
Now, my lord, consider my application or objection which was filed. That my lord will kindly turn to page 26.
Yes.
This was filed on 30th January 2019.
And the hearing was called on 18th September.
Yes.
That is
Then
also
how-
prior to the award.
Yes, then my lord, how this report can be filed that there is
Was
no
this
objection?
hearing made?
Yes, we appeared but no order. Still that my lord, in view of the provision as mentioned in the statute itself, the authority has to pass an award rejecting my application or rejecting my prayer regarding that you are not entitled. There is no order to such effect. If the order is not passed, my lord, then they have to refer the matter before the principal civil court for apportionment of the award. But here, my lord, 7 except giving, I do not know what they have heard or what they have said, But award, according to them, the award was declared prior to that, disbursement of money was made, everything has been done. And that was considered by this honorable court also. Once if the award is declared in favor of somebody and the money has been given, then what will be the courts open to the honorable court? My lord, subject to question, it is the unreported judgment, my lord. Only I have handed. আমি দিয়ে দিচ্ছি কপি, আমি দিয়ে দিচ্ছি, এটা আমাকে দিয়ে দেবো, বিবেক জাস্ট বিবেক চৌধুরী। Internal page 8, the same fact, my lord, there is dispute between the apportionment, the money was disbursed, there, my lord, hearing was given, no order was passed. Page 8, this dispute cannot be resolved. My lord, got it.
But here there was an arbitration. This is a different case.
No, after that, my lord, the award was declared. After that, my lord, page 8, my lord, can you turn to page 8? This dispute cannot be resolved by the competent authority. When the claim of the title of the piece of land or property is under dispute, the civil court is the competent authority to determine the issue. Therefore, both the petitions are disposed of by directing the competent authority to refer the matter with the learned district judge Jalpaiguri, invoking the provision of 3H4, which is, my lord, used to direct of the act. And the learned district judge shall dispose of such matter with the above objection made by virtue of the decision of the division makes such and such. The respondent of such and such are directed to refer the dispute to the learned district judge Jalpaiguri for decision 2 weeks from the date of the communication of this order. Is namely, Rabindranath Sarkar is directed to deposit the compensation amount in respect of 14 decimal of the acquired land of the district judge Jalpaiguri to contest the reference. So my contention is, my lord, before your lordship, not only the amount, but the proportionate amount which is now he is enjoying, that should be deposited before the district judge for the purpose of participating in the reference. Because I'll be nowhere. Today, my lord, if the degree is passed, then that will be a paper degree. The my lord knows on the earlier occasion, the state says it is with the private respondent, so we cannot do anything, we cannot recover. So even if, my lord, as on this day, my adjudication has not been made, from the report, my lord will find there is no iota of evidence that my objection has been considered and rejected or anything. On the contrary, they said that I did not raise any objection prior to passing of this award. From the documents I am satisfying your lordship, that not only the passing of the award, I have raised my claim and hearing was given.
But when there is a question regarding apportionment,
yes,
the private respondent cannot be here. The private respondent has been directed to deposit.
Yes, here, my lord, the money has been given to
the amount with regard to your share.
Yeah, my share.
So this court is, in other words, determining the share, which cannot be done.
No, that is the disputed.
Only to refer the matter before the.
That is the.
Only that could be well sufficient.
Now, my lord,
regarding deposit of the amount,
deposit of the amount, if that be so, my lord, then the state should take the responsibility for disbursing the amount.
What had happened, my lord? My lord, in my report,
the entire amount should be deposited with the district judge, not only your share.
Yes, yes.
Because there should be an apportionment after that.
Yes, my lord. Because state cannot absorb his responsibility.
My lord, your lordship kindly see in our report.
Yes, your report.
My lord, the fact is that, my lord, when we went to the field for making an inquiry, at that relevant point of time, the petitioner was not available. Even no documents which we sought for, they did not produce. That's why we were present before us. And my lord, your lordship kindly see the, my lord, award slip we have annexed in our report. My lord, kindly come to, my lord, page number 8, 9 in our report, my lord. Kindly, your lordship kindly come. Page 7, 8 and 9. 9 is the award, Gauranga Mondal. Total Gauranga Mondal award is given 65 lakhs 12,932. Then, my lord, kindly come to, my lord,
7.
Page 8, page 9. My lord, in our my lord, affidavit, my lord, report in the form of an affidavit.
Page 9, yes.
Yes, my lord, page 9. Your lordship, my lord, kindly come to page 9. 9 Gauranga Mondal, we have paid 65 lakhs 12,932. Then, my lord, 2 Kamala Query. My lord, Kamala Query number 2, she has been paid 18 lakhs 89,924. Then, my lord, kindly come to, my lord, page number 11, Samiron Mondal, she has been paid 69 lakhs 3,959. Then 4, my lord, Sudhir Mondal, he has been paid 69 lakhs 3,567. My lord, respective amount, my lord, whatever the share would have there, we have paid to them.
When was the payment made?
Payment has been made, my lord. It has been stated in our report, my lord. Your lordship kindly come to paragraph 8. Paragraph 8, the award never raised. Page 3. Page 3.
my lord, where award has been paid, my lord, 11/12/2019, page 3. The
Award?
status of the award is stated below. 11/12/39 and 11/12 and 11/12. Whoever present there, whose land has been, my lord, produced and a relevant document was produced, my lord, we have paid the amount. My lord, the petitioner was given an opportunity, your lordship has kindly seen. My lord, we received the letter from them prior to that. But he was never present there. Prior to, in the month of January, we received the, my lord, objection from them. And the award has been paid in the month of my lord, December and September and December. They never present at the time of my making an inquiry.
Payment in the payment sheet itself,
Yes, my lord,
page 8, 9, 10, 11, where is the date?
receipt paid, my lord, there is specific written, my lord, page 3rd lot, page paid. Lot
Where is the date?
Well, the award was, very well. Award was declared, award was paid after my objection. Whether consideration of my objection in terms of 3H3. Under the statute. National rate, wait a point. I do not know how the record of rights can.
Date of payment of the award also.
My lord, what my learned friend is submitting on the record of rights converts in title interest of the immovable property in the property in question, or who's standing on the date when the inspection was held, he will be declared to be the owner of the property. If this is the, my lord.
So, my lord, already, my lord, we have paid the entire amount of the award. So let them, my lord, let them, my lord, let them, my lord, let the, your lordship, my lord, so far the judgment produced by my learned friend, that is quite correct. Let them deposit the entire amount to the, my lord, district judge, my lord, and the, after, my lord, consideration of the proportionate share of the amount, that should be paid to them.
How do you explain payment of the entire amount pending objection of the petitioners?
My lord, that has been paid, my lord, now what we have to do, my lord? It has already been disbursed.
Property.
My lord, they are not present at the time of our disbursement.
Disbursement,
Send give them a notice?
Yes, my lord, they are offering. My lord, we have given the notice to them. My lord, you have lordship has seen.
Notice is a payment notice?
No.
Then? It was
Hearing
an
what?
objection hearing.
They are giving the opportunity of hearing, my lord.
Where is the
They
hearing
remain
order?
present.
Where is that order of hearing? Even if it says that they were not present? Please show me the order. Where is the reasoned order?
Order, my lord, at the time of, my lord, they are directed. They are directed to be present at the time in the field inquiry, and also, my lord, at the time of disbursement of the award. They never produced any document. They are never present at the time of my inquiry.
Did you serve a notice of payment? After that, they are supposed to go and receive the award or remain present, isn't it? Where is the notice? This is a notice of hearing of the objection.
3H3, in terms of 3H3.
Yes.
There is no decision on 3H3. Payment made.
Where is your order on 3H3? Even rejecting the prayer of the petitioner, where is that order? Could you have made the disbursement before disposing of the objection?
Simply, my lord, by making an objection, they remain silent. And even 2021, when they made the writ application.
Please may understand what you're submitting. They have made an objection. You have given a notice of hearing of the objection. The petitioner appeared or did not appear. Where is the order? Disposing of the objection before you disburse the amount?
Your lordship,
Yes.
your lordship kindly direct the whatever the judgment so far passed by the
What does
coordinate
the
bench.
have to say? Yes.
My lord, if my lord may kindly take my lord the prayers made in the writ petition.
Yes.
The rate of in the nature of mandamus commanding the respondent to show as to why 50% compensation should not be paid to the petitioners in reference. My lord. Second, my lord, is the rate in the nature of mandamus commanding the respondent not to disbursing the compensation as assessed in respect of RS plot such and such.
Yes.
But a declaratory, my lord, a relief has been sought for, my lord. My lord, whether the petitioner is the owner of the land or not. That is, my lord, my lord.
Who will decide?
My lord, that is the competent civil court, my lord, will decide.
Yes.
My lord, and my lord, one thing, my lord, in the writ petition, my lord, they have sought, my lord, they have said that they are the owner of the 10 decimal of land. My lord, subsequently in a supplementary affidavit, my lord, they have said, my lord, they are the owner of the 7 decimal of land.
The same thing. Who
My
will
lord,
decide? This
my
court
lord,
will
the
not
civil
decide,
court
is
will
it?
decide, my lord. My lord, and my lord, with respect to, my lord, the submission made by the petitioner, my lord, if my lord may kindly come to, my lord, the report, my lord, at my lord para 8, my lord, once, my lord. I will show, my lord, the documents
Paragraph?
8, my lord.
Yes.
But even no copy of the writ petition has reached this today's end. The applicant's petitioners were also given opportunity of hearing as natural justice and explain such verified possession of the awardees. Even the petitioner has been intimated the status and finding regarding eligibility awardees against his RTI application dated February 15, 2019. That in spite of receipt of such information communicated to them on September 6, 2019, wherein the particulars of the awardees were mentioned, the petitioners before disbursement of award never raised any objection on the decision of the department, nor made any claim over their demand. But I will, my lord, basically, my lord, adopt these, my lord, the submission of this state, my lord. My lord, despite there
Which
being
is
an
no
objection,
submission at all.
my lord, despite there being a, my lord, the objection raised by the petitioner.
Sir, you have to deposit the entire amount received by you before the civil court. Let the civil court decide.
Yes.
And that too within 7 days.
My lord, some,
You have taken an amount which is not which you are not entitled to.
my lord, they have, my lord,
And you've been enjoying that amount since 2019.
4 years already passed.
my lord, they have, my lord, raised an objection, my lord. They've never produced that objection. They've pressed that objection, my lord. After, my lord,
How
the
do you
award has
raise
been.
an objection after raising it?
My lord,
Please tell me.
my lord, they did not, my lord, produce, my lord. That,
They did not?
my lord, produce that award, my lord. My lord,
Where my learned friend is submitting? Is there any order? I put this
Mr.
question.
Roy, please take your seat, Mr. Roy.
my lord,
Yes.
they ought to have, my lord, filed the writ petition at that point of time, my lord.
Which
But
point
after,
of time?
my lord, when, my lord, their objection was not considered, my lord. My lord, they waited for that time. My lord, the
2019.
award was paid. My lord, after that, my lord, they have
The
filed.
writ
the writ
petition, when was this writ petition filed?
My lord, November 2019, my lord.
Yes.
My lord, sometime in November 2019, my lord. I
So
don't
where
have
was the delay?
Lord,
Deposit the entire amount, sir, within 7 days.
then, my lord, sometime, my lord.
The lengthier your submission, the days will be decreased.
My lord, regarding the date, my lord, your lordship payment, your lordship kindly come to page number 40. Page number 40.
1/4.
Yes. No. My lord, that is agency-wide e-payment status.
Yes.
Agency-wide e-payment status.
Page 14 of the writ petition.
Yes, my lord.
1/4.
In our report. In our report. In our report. In our report, my lord, page 40. E-payment status.
1129.
1129.
That is after my objection.
1129. My lord, all the my lord checks by checks we have paid. My lord, date is there. 30, 11.
10, 11, 19, when the objection was still pending.
Yes.
How do you explain?
And last
That's
question,
why
my lord was pleased to direct
lordship
whether
might
any
get one.
objection you have raised or not. Supplementary, which is my learned friend also.
Objection is on record.
But apart from that, there's certain objections has also been given. It was filed on 30th January 2019 and 33 last documents as per the notice.
Everything is in fact has been admitted by the state.
Yes.
Who has kept the objection pending and given the amount?
A reason based known to the authority why this amount was given.
Reason is best known to all of us, not only the authority. These extraneous considerations need to be stopped. Heard learned counsels for the parties.
May I have a lordship leave? My learned junior is there.
The petitioner's SL poll apostrophe grievance is that Though the petitioners are co-sharers of land in RS plot number 2396, measuring 20 decimals. 2396, ওখানে লিখুন in Moja, Kantadih, Kantadih, measuring 20 decimals, comma. The entire decimals along with the private respondents, comma. The entire compensation for acquisition of the said land has been paid to the private respondents despite the petitioners raising objection to the same. Stop. The petitioners have been deprived of their legitimate share of compensation. Paragraph. The petitioners, comma, by a letter dated 30th January 2019, written to the Special Land Acquisition Officer, comma, Purulia, comma, requested payment of their share of compensation in lieu of acquisition of the plot in question. Stop. Pursuant to the said application, comma, a notice was issued by the concerned authority fixing 23rd September 2019 for hearing of the application. Stop. According to the petitioners, comma, no further communication was made to the petitioners. Stop. In reply to an application under the Right to Information Act 2005 made by the petitioners, on 15th February 2019, comma, the petitioners were informed on 5th September 2019 that the entire compensation was paid in favor of the private respondents. Paragraph. The report in the form of affidavit submitted on behalf of the state respondents demonstrates that the award was disbursed in favor of the private respondents on 11th December 2019. Stop. No explanation has been given by the state respondents as to how such award was disbursed in favor of the private respondents only when the application filed by the petitioners claiming compensation as co-sharers of the plot was pending before the authority. Stop. Instead of referring the matter to the civil court having jurisdiction to deal with the matter under section 3H4 of the National Highways Act 1956, for apportionment of the compensation declared in favor of the owners, the state authority chose to disburse the entire compensation in favor of the private respondents for reasons best known to them, having no legal basis. Paragraph. Since the petitioners as well as the private respondents claim to be co-sharers in respect of the plot in question and also claim to be entitled to compensation declared by the authority, the said dispute cannot be resolved by the state respondents. Stop. The matter needs to be referred to the civil court under section 3H4 of the Act of 1956 for determination of title of the parties in order to apportion the compensation payable to each one of them. Paragraph. In view of the above, the writ petition is disposed of, directing the special land acquisition officer should refer.
Yes, one number 3. The competent authority you get to be
The competent authority under section 3A of the Act of 1956A of the Act of 1956, being the third respondent herein, to refer the matter to the District Judge Purulia, to the learned District Judge Purulia under section 3H4 of the Act of 1956 within 7 days from the date of communication of this order. Paragraph. Upon such reference being made, the private respondents shall deposit the entire compensation amount received by them as referred to in the payment list annexed to the report in the form of affidavit submitted on behalf of the state respondents within 7 days of such reference. Paragraph. The learned district judge is requested to consider and dispose of the reference as expeditiously as the business of the court would permit. Stop. Upon receipt of the said amount, learned district judge is requested to upon receipt of the said amount, the learned district judge is requested to deposit the said amount in an interest-bearing auto-renewing fixed deposit account with any nationalized bank till disposal of the reference, so that the amount be disbursed in favor of the eligible persons upon deciding the reference. And disposal.
Milord, one clear, Milord. Milord, can it be, Milord, 15
তারপরে ওটা
days?
as expeditiously as the business office. With the above observations, the petition is disposed of. Gentlemen.
Milord, can it be 15 days, Milord? No, Milord, the deposition. Milord.
It is lying in your bank, sir. You have already enjoyed interest
Milord, I
for
will, Milord, have to
4
communicate,
years.
Milord, with the client, Milord, 10.
You'll
Milord,
get
15
more than
days.
15 days because reference to it not
Yes,
can be
yes.
done after
You'll
that
get
notice
more
be
than
issued after that 7 days.
7 days after reference.
Now state will take care of the sending the matter for reference.
Absolutely. 7 days. Come back in contempt otherwise. Disposed of.
Grateful to your lordship, my lord.
Very unfortunate state of affairs. Next.
Item number 22.
My lord, I am praying for a not to the lordship on behalf of the learned advocate Juhi Dattagupta lordship.
For the petition.
For the petitioner, my lord. I'm
You are for the
he just
petition?
told me, my lord, to
Several adjournments taken. On prayer of the petitioner, please be ready on the next occasion.
but I just
Several adjournments
she just
taken.
told me, my lord, to
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 5th July.
I will inform her.
Next.
23.
My lord, I am for the petitioner. Pursuant to my lord's last direction, I have served upon the private respondent. This is my affidavit of service.
Who is appearing for the state?
On the last day, nobody appeared.
For the
Sir.
state also, nobody appeared.
Yes. Service upon the state is complete. On 28th of April, I submitted the affidavit of service. Wherefrom it will appear that state respondents were served.
Yes. So may I request Mr. Dey to appear? Please serve a copy to him.
Okay. In course of
Yes,
the
what is the matter about?
my lord, petitioners land partially acquired by the state authority. My lord, kindly come to page 19 where I have annexed the deed of the petitioner, and
Yes.
award was given. Kindly take page 31, annexure P2. The case of the petitioner is this: the amount which has been given as compensation is inadequate compared to other parties who was on the same footing. One of the awardees.
This is under the Highways Act?
Yes, National Highway Act. The land acquired is 16.25 acre and compensation is 34,45,000. After receiving this, kindly come to page 33. It is the representation made on behalf of the petitioner within a month, where the petitioner made dispute, and kindly take page 34. Come
This
to
has
page
not been considered as yet?
No, not yet considered. Thereafter, another representation was given.
That is a demand of justice.
Demand of justice, but last page 46, page 6, P6. My lord, I can show from this. Kindly take page 35.
Page?
page 35, this is the right one application under Right to Information Act. Information was sought for from the state respondent regarding the compensation granted to other persons who are on the same platform. Kindly come, this is the right. And the reply
If
is,
you're aggrieved, your recourse is under 3G5.
yes,
So let your 3G5 application be considered by the authority within a stipulated time frame.
but kindly, that is my prayer also. Kindly consider in that case prayer E, because the respondent is trying to start work in my land.
No difficulty if you are given compensation.
No matter, compensation is inadequate.
Individual is not necessary. This is a public project. So
Kindly
individual cannot be
grant me limited protection,
No.
my lord, for limited period till the disposal of this.
compensation has nothing to do with utilization. If you're entitled to compensation, enhancement, you'll be given. Isn't it? That's a different recourse altogether. You cannot stop public work for that.
If
Work cannot be discontinued for that.
no, they are, I'm not,
Let your
I'm not on
3G5
that.
be
I'm not-
considered within a month. Mr. De?
Malda.
Please serve him a copy.
আজকে দিয়ে দাও।
Affidavit of service. None appears for the respondents despite service. Mr. De, who is present in court, regularized Quran, copy service of direction. Paragraph. Being aggrieved by the compensation paid to the petitioner for acquisition of his petitioner for acquisition of his land
Commissioner.
under the National Highways Act 1956, the petitioner filed an application under section 3G5 of the Act before the competent authority on 16th April 2018, which is yet to be considered. Stop. The petitioner complains that other landowners similarly circumstanced with the petitioner have been granted more compensation than the petitioner by the authority. Stop. The petitioner prays for consideration of his application at the earliest. Paragraph, it is submitted on behalf of the state respondents that three,
Respondent number 3.
the third respondent be directed to consider the application in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the application filed by the petitioner under section 3G5 of the Act of 1956 on 16th April 2018 within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph, it is needless to mention that the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Grateful.
Disposed of?
Urgent certificate copy, my lord.
Yes, sure.
Urgent certificate. Grateful.
Number 24. I am for the petitioner, my lord. But I for the respondent, as per earlier direction, I
State.
My lord. Respondent number 9 is the my lord.
You're for both the private respondents?
Only for each.
Only for 8.
9 was before.
9 is also your brother. Brothers are quarreling. Deepak Jana served. What about the state? Served.
My lord. Person served. The hand service, my lord.
State cancels. State,
Originally served, subsequently notice was served to the state, learned advocate appearing on behalf of the state. My lord, page number 3. Omrikal Chatterjee.
was anyone appearing?
My lord, Omrikal Chatterjee.
Page number 3.
My lord, of evidence service. Bottom, my lord.
Who is this Mr. Amritulal Chatterjee? I do not find him in any of the matters. But he doesn't appear in any of the matters. So may I request you to appear so that I can dispose of the matter?
My lord,
I have not seen him in court at all, Mr. Dev. I will not allow his name. In an earlier matter, I have not seen him in any of the matters. Yes, what is the matter?
my lord, matter is regarding the unauthorized construction, I have the West Bengal Highway Act 1964, my lord. The representation was made, my lord. That is page 29 and SRP2. That is considered by the assistant engineer, my lord.
Page 29.
My lord, page 29, my lord, and SRP2.
Let it be considered. Yes, anything to add?
The representation, he said his land is just adjacent to the PWD land and I make an unauthorized construction over the government land. Now kindly come to my page 24, his deed.
24.
24. The boundary of the deed. In the middle portion, my lord, Amar Khorida, it starts with Amar Khorida, 11 decimal মধ্যে উত্তর পূর্ব কোণে 2 decimal অত্র দাগে শঙ্কর জানা. He himself admitted that I have a personal property over there.
Yes, I have not, there is no dispute, my lord. But that is not.
Where are you reading?
But in the middle portion, madam.
Of page 24?
Page 24.
তফসিল জমির বিবরণ.
তপশিল জমির বিবরণ.
Yes.
First, second, third, fourth, fifth, sixth, seventh line, madam.
Yes, sir. I have no objection about.
The boundary of his property. আমার খরিদা 11 decimal মধ্যে উত্তর পূর্ব কোণে 2 decimal উত্তর দাগে শঙ্কর জানা পূর্বে নয়নজলি.
পূর্বে নয়নজলি. That is my allegation. Part my lord. My allegation. On the allegation of the.
But kindly take the mic up, we have parked him.
Only for the land owned by the PWD department.
He has no allegation. He has no complaint over your construction in your own land. He says you have extended your construction.
His land is adjacent to PWD land.
Yes.
And I make an unauthorized construction over the PWD land in front of his house. And his deed says I have a personal property over there.
Yes, yes, I have no objection about that. Not at all.
In the representation.
You may have extended your construction from beyond your personal property. So let the authority decide. They'll remark it. Affidavit of service. None appears for the state respondents and respondent number 9, despite service. Paragraph, Mr. Dey is present in court, regularized court, copy service direction. Paragraph, the petitioner claims to be the recorded owner of the plot in question and complains that the private respondents have raised unauthorized construction by encroaching upon a portion of the PWD road adjoining his plot, comma, thereby obstructing his ingress and ingress. The petitioner submitted a representation in this regard before the concerned authority on 31st December 2019, which is yet to be considered. Stop, the petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the state respondents. It is submitted on behalf of the private respondent, number 8, that the private respondents have raised construction in their Rayati land and have not encroached upon any portion of the PWD road. Paragraph, it is submitted on behalf of the state respondents that the second respondent, be directed to consider the representation in accordance with law. Paragraph in view of the above, the petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents. Comma in accordance with law. Duvarna, in accordance with law. Disposed of, etc. Next.
Disposal.
25.
Yes, anyone for the petitioners? None appears for the petitioners. No accommodation is sought. Let the matter appear under the same heading on 12th June. Twelve.
26.
Anyone for the petitioner? None appears for the petitioner. No accommodation is sought. Let the matter appear under the same heading on 28th June. 28. You are the petitioner. You are asking for some time on prayer of the. On the earlier occasion also you sought for an adjournment. On prayer of the petitioners, the matter is adjourned. Let the matter appear under the same heading on 6th July. 6th July. State.
I'm for the state. দিয়ে দিস না আমি আর ফোন টুকু আছে
Next.
Number 28.
Yes, petitioner.
I am for the petitioner. What happened, my lord?
Have you served the respondents?
Yes, but during the pendency of the petition, the grievance has been redressed. This is relates to unauthorized brick field operation of unauthorized brick field. The petitioner
Let
lost,
it be disposed of.
and that is stopped.
It is submitted on behalf of the petitioner that during pendency of the writ petition, the grievance of the writ petitioner has been redressed. Paragraph in view of the above. Nothing further remains to be adjudicated in the writ petition and the same is accordingly disposed of. Urgent certified website copy. Petitioner? No one. None appears for the petitioner. No accommodation is sought. Let the matter appear under the same heading on 7th July.
Number 30.
Lord, this matter, my lord. Well, it had passed an interim order, which was extended till 15th of April, my lord.
directing us to implead the Zilla Parshad as a party. We have done that. We have also served upon them. This is our affidavit of service. Pursuant to your lordship's order. That endorsement किया था उसने हमें
Mr. Sengupta is appearing for all the respondents, I believe. Yes.
I don't know whether he is appearing for Zilla Parishad or
You have served the Jilla Parishad?
I have served affidavit in services there.
Right, so we can continue, yes.
Zilla Parishad we have served. We had our contention was that a particular road which forms part of my land, on which road was being constructed, and my lord had passed an interim order to that effect, and a report was called for. After much delay, they filed a report, which was before my lord. Wherein, report
They say it has been concluded long back.
No, my lord. It is continuing, my lord. Therefore, my lord passed an interim.
Ongoing.
Ongoing. Therefore, my lord passed an interim order. Now, my lord, we are saying it's our land. A civil suit is pending, my lord, with regard to that particular land and the adjoining land between me and my brothers in the civil court, and my lord, at Baravi. And there an interim order had been passed for injunction. Subsequently, there too, we came up before this honorable court.
Injunction between parties inter se.
Parties inter se, but then that property is also injuncted because now the state cannot come and encroach without any notice upon me. This is my case. Now, my lord, the report, if my lord kindly takes up, second page, will it? My lord has got the report.
Yes.
My lord, second page, my lord, last paragraph, my lord. During inquiry, by visiting the place in question, was learned that the petitioner Haran Mandal has a long-running land dispute with his brothers, Naran Mandal, Paran Mandal, both son of so-and-so. All the brothers with their families do live adjacently in their respective dwelling houses. The family members of the brothers of the Kacha pathway as common pathway for all. Recently, the Kacha common pathway has been converted into a Pakka concrete made pathway by local panchayat under the. Now, my lord, here lies my contention. Now, my lord, the civil dispute is pending between brothers. Admittedly, according to the government officers, my lord, that is a private land or a common passage between the two lands. It does not belong to the government. Now, that particular path is being made into concrete, where I also use some part of it for my cultivation and as my passage, which is giving me access to the mainland. Now, be that as it may, my lord, when a civil dispute is pending before a competent court of civil jurisdiction, where there is a prevailing order of injunction of maintaining status quo between parties per se.
Yes.
Now, my lord, an order, we came before they started making certain encroachments. We came before this honorable court in the writ jurisdiction for police inaction. This honorable court reiterated by way of an order that the order of the civil court should be maintained. Now, my lord, in between that, my lord, this construction work started. Now, my lord, without there being any right of the government per se in the land which is in common between two respective parties, my lord, can a concrete road be constructed? This is a question I ask myself. Now, my lord, what happened, my lord? I am a very poor rustic person, my lord, who with great difficulty comes before this honorable court or any court of law. Now, my lord, what had happened is, my lord, we filed this way back in 2021, my lord. But as faith would have it, my lord, it could not be heard because of the ongoing pandemic. Subsequently, then the state government could not come up with a report in spite of several orders, be that as it may. Now, my lord, what I am on is, my lord, number, the state has stated that recently the Kacha common path has been converted. Now, my lord, they should come up that what prompted them to make this Kacha pathway into a concrete road under the Manrega scheme without the consensus of the petitioners. There should be, when there is a civil dispute pending, the court is in season of the matter. Now, my lord, what I am humbly submitting is, my lord, since they've started, my lord, may I come, my lord, with the certified copy of the recent orders of the learned civil court for my lord's perusal, my lord, because, my lord, this cannot go, any scheme, my lord, under the sun, my lord, the government is a welfare state. Government can make any road pakka when it is kacha, but not in between my house.
The road was already existing.
My lord will appreciate this thing. There's a land which is enjoyed by our family members. And there is copasanary or korta system, whatever it is. Now, my lord, in villages, my lord will perceive that in villages, my lord, small hamlets are there. And there is no government road. They make their own private pathways which reaches to the main government road. That is the inner internal understanding.
It was a kacha road.
Kacha road, my lord, but
say if that is made pakka, it will
No,
continue to your benefit also.
no, my lord, it is not to my benefit. When it is being made pakka, there is, my lord, the portion which I was enjoying, I was cultivating as a small saplings or small things which we always do on the particular, in the courtyard, which is just in front of my hut. That has been taken away. They've encroached upon that. They have widened the road. How could they do that?
And your co-sharers say that is not your portion at all. So I
My
think
lord,
the
if
civil
it is
court has
a
to decide.
co-sharer, my lord, that is a civil dispute, my lord.
The civil court has to decide first.
My lord, I bow down, but how the state government comes?
Have you implemented the state government in the civil suit?
My lord, that is what my lord, that was the
Mr. Sengupta, please. You'll have your turn.
My lord, what I am humbly submitting is,
Have you implemented
even
the
if,
state government?
my
in
lord,
the
in
civil suit?
my respectful submission, my lord, there are authorities, my lord, in an ongoing civil suit. If I have to implement the state government, even as a performer, if a performer defendant is also there, either I have to give a notice under section 80, or I have to take,
Can be exempted.
or exemption is to be taken under 83. Now, my lord, apart from that, when this started, I came helter-skelter before this honorable court, saying that, and because of the dereliction in filing a report and bringing the exact position before my lord, the entire thing took around 2 years. So, my lord, I am a person, a citizen, a poor citizen of India who's being made to run from pillar to post, where prima facie the government does not have any right to make any construction of any pakka road in a private property.
I think your recourse lies before the civil court.
My lord, I shall go for, I am before the civil court, but my lord, my recourse lies before the civil court. What will stop their hands? I am
Why didn't
pleading.
you implement the government before
My lord,
the-
I shall let the construction has not been completed.
The order of injunction covers them also.
My lord, my lord, if my lord, with deepest of respect, if I need the order of injunction to prevail over them, I cannot implement them as pro forma defendant.
No, why
I have to,
defendant?
then, my lord, section 80 is a stumbling block unless I get a leave from the learned civil court below.
There's an
Until
urgency.
that time, when I get the leave, again the whole construction will be completed.
The leave has become a formal issue now, isn't it?
My lord, what I am humbly submitting is, first of all, my lord, the first submission is,
Want to come back with the orders, you can, but I really have my doubts
If-
as to whether this court can interfere.
my lord, in that case, my lord, if it so falls from my lord, subject
Without
to correction,
wasting further time, why don't you implement the state?
my lord, I will, my lord, but with some protection. If my lord disposes my application with this observation that I should go before the civil court, impleading them, my lord, with my lord's vast experience, my lord, how long it takes before a civil court to implead, then get an objection, then again state government will come.
That is the framework of law which we cannot.
My lord, but then protection, my lord, technicality is handmaid of justice, my lord.
Your,
My lord,
title
my lord will kindly protect me.
Your
Stop
title
them
is
from
in
making any
dispute, I
construction.
cannot.
My lord,
Your title is in dispute before the civil court.
my
How
lord,
can
it is
this
not
court
in
protect
dispute.
you?
My lord then my lord, I will come with the plaint.
Come
It is
with the
not dispute. There is no dispute of
So
title.
we'll spend further time on this, come back.
My
with
lord,
the plaint if you
maybe,
want
my lord,
to.
we will, but my lord, I'll be
Please come
particular,
back.
because without getting a comprehensive order from this honorable court and being before my lord for last 3 years, my lord, it will not serve any purpose of this poor man. So, my lord, what I'm humbly submitting is there's an interim order, my lord.
Interim order has already expired on
My lord,
15th April.
My lord,
Today we are on 5th June.
my lord,
So I don't think it can be extended at the moment.
my lord, in my respectful submission, then my lord, let me come back on, my lord will give me 1 week's time. my lord.
Let him come back.
My lord, subject to my lord's approval, my lord, kind of, my lord,
Please switch it on. It's switched off.
yes, my lord, subject to my lord's kind approval, my lord, days and days, my lord, he is taking time, yes.
My
for
lord,
the
I am
time
taking
being-
time.
No, no,
I
my
take
lord,
serious
what the-
exception
no,
to
no,
these submissions being made from the bar.
My lord, kind,
The records will speak for themselves.
which is,
Why he makes aspersions unnecessary without even going through the records?
Let him complete, please.
Well,
Yes,
first he started with an aspersion that I am taking time.
Please.
my lord, probably, my lord, he doesn't understand what is.
I do
my
understand
intention.
very
Yes,
well
my-
whatever falls from his mouth.
My submission is, my lord, to that effect that what relief he can seek before this honorable court. I just put that question to myself. My lord is already made an observation. Already Kacha road is there. He is not denying that. It was converted to Pakka road. It was complete. So, my lord, what relief he can seek for by filing this writ petition. I just put that question to myself. Only options, my lord, the poor man or poor lady, that is not helping him. Only think the approach before the civil court, file an application, implead them, and if the state is doing something wrong, punish the state. There, what relief he can seek for? My lord, I just put that question to myself. What relief?
If he wants to come back with the documents, you can, but I really don't think it will
My
add.
lord, unnecessary, my lord, is,
my lord,
what I mean to submit, my lord, unnecessary, he is, well, this, my lord can give them time, I am not on that, but my lord, what relief, my lord, I just put Rao, my lord, even after that, there is a co-sharer. Now, my lord knows that in village, my lord, the co-share of the co-sharers, my lord, has given the, yes, proceed with the Pakka road. It was converted to Pakka road. My lord, he is benefiting with that. My lord, only thing, my lord, regarding he is what? He is only intend to get the compensation. What relief he is seeking for? He cannot. My lord, I could have understood it is the owner, his ownership, because he is the sole owner. Then question would be, otherwise, my lord can say that Mr. Sengupta persuade them so that he can get compensation or give them a hearing to the district magistrate so the district magistrate may consider. But my lord, this is undisputed.
Sengupta, he's still entitled to compensation.
Compensation, my lord, kindly consider. My lord, kindly consider one thing. My lord, the dispute relating to co-sharership. Somebody has already given consent, you just, in favor of the state, you just, because my lord knows that Pradhan Mantri, my lord, the central government scheme, that only compensation, my lord, let it be decided by the district magistrate. Let it just, my lord, can you dispose of this application? If he's, my lord,
Apportionment dispute will be there.
apportionment, kindly consider one thing, my lord.
So the civil
This
court has to
dispute, my lord, dispute is before the honorable civil judge. And my lord, he is enjoying an interim order status too.
He's not
State
enjoying
government
any-
is not, my lord, is not binding upon the state government because state government has not been implemented as a party. Only my lord knows that is the only practical purpose. There is only 1 day time, just 80 with the section 80 notice, and my lord, proceed with that application. Or my lord, he can, my lord, kindly consider one thing. My lord, I am not, what is reasonable, I am making that humble submission. My lord, and suppose he, my lord, gives time. What more he can get, my lord? My lord, no, I could have understood, first of all, my lord has passed so many orders in others' application. I could have understood he is the sole owner. In spite of having consent or getting consent from him, the road was converted to Pakka road. But no denial that was a Kacha road. It was converted because consent was given most of the co-sharers. Only
Cuff, he is making submission. Let him come with the report of the cuff making submission on
my
the
lord,
behalf of
kindly
state government.
consider this
not
is the
commendable.
road.
Let us not
This
spend
is
more
the-
time on
What I'm
it.
My
saying,
lord,
my lord,
this
let me
is-
come back.
Back or do you
Yes,
want
my
to-
lord, I want to come
What-
back, my lord.
Why? What more?
Sengupta, he is the petitioner.
My lord, I have answers to all his questions, but I don't speak from the cuff. I speak on the record.
Come back.
He doesn't even know on the record whether consent was given by whom, how, where, and on behalf of the state government, he's making submission from the bar.
My lord, then my lord, my submission would be, my lord,
Let him come to the
he
record.
cannot get any relief from this honorable court because suit is pending. My lord, suit is pending, dispute is there. That injunction he is, my lord, already enjoying. No, my lord, kindly consider there cannot be two parallel proceedings.
If he
Because the
still
title, question of title,
wants to come back with the orders, documents, let him come back.
documents, he wants to realize some. Yes, ma'am.
Documents,
Kindly
orders of the-
kindly record what documents he will, well, kindly
Lord,
record. Yes. Kindly record.
I
He
am
will
not shying off from any recording.
Kindly
My lord,
record.
I have,
Again, he will make the same submission.
my lord,
affidavit of
my lord,
service.
again, my lord will kindly see the records. How many times he has taken time, he is not even found.
No, only report.
My lord will kindly see.
My lord,
He's now making aspersion that
no,
I'm
my
taking
lord, no, my
time.
lord. I never made any aspersion to
At the
that
very
extent.
outset,
No,
when he said
what I made my submission was, my lord,
live streaming, I would have
submission was,
replayed
my
it.
lord, submission was what relief he can get by filing this.
Sometime, please come back with
My
the
lord,
documents
I am
that you
just
want.
wanting to have the record as to what is going on in the trial, because again, making submission, the status quo has become absolute. So therefore, I want to go through that particular order sheet and come before my lord and conclude my submission on the next.
Yes.
That is what I'm trying to
My lord,
humbly submit.
my lord, but my lord, two parallel
Because
proceedings cannot-
because a civil proceeding is pending, and hence, since it has fallen from my lord, that there can be an alternative remedy there for me. So, my lord, without asserting the record, I cannot make any submission and ask make submissions on behalf of my client.
You want to take further instructions in
My
this
lord,
matter.
that's what I'm trying to say, my lord.
And none appears for the added respondent despite service. Paragraph. Since a civil proceeding is pending between the petitioner and his co-sharers with regard to the plot in question, comma, learned counsel seeks to take further instructions in this regard. Paragraph, let the matter appear under the same heading on 29th June.
Intended, my lord.
Obliged.
I'm grateful. My lord.
Number 31.
My lord, in this matter, I beg to appear for the petitioner led by Mr. Patravatim Roy. Mr. Mondol is appearing, my lord. This matter was taken up by my lord Justice Ravi Kishan Kapoor on 24th August 2021. There was direction to take instruction by my senior learned friend, my lord. I am seeking, my lord, reference under section 18, my lord, that was made within time, within limitation period, my lord. 10 years have gone, my lord. Till date, I don't know what has happened to my application. That is at page
Yes, Mr.
60.
Mondal. Page.
তাই যদি instruction না থাকুন তাই আপনি বলুন কারণ instruction
Has the reference been made?
Also, according to the application annexure P1, the notice issue, my lord, kindly 27.
This is a 12-2 notice.
Yes,
7 notice, my lord. And made an application, my lord, after 6 months. So the limitation question is raised.
my lord, kindly
When did you
consider.
receive the notice?
My lord, notice was received on 11 September 2012, my lord, at page 4, paragraph 5, my lord.
Lordship, kindly see page 15.
That is issuance.
Lordship.
When was it received?
That is on 11 September 2012, my lord. My lord will find it
There is no
at
any
page 4.
Otherwise, the
My lord, that is
consider the
specific government at
representation
page
annexure
4,
P2, my lord, there is
paragraph
no
number 5,
objection.
my lord. And it was made on 18th October 2012, my lord, within 1 month from the date of receipt, my lord.
From
I
the
have
date
received
of
the
notice
compensation
within
by
6
with
months.
objection.
From the date of the notice within 6 months is the limitation.
My lord, that is notice issued on that day. When it was received by me, that is
There is
important,
no-
my lord.
Suppose you issue a notice and do not serve it within
Yes,
6 months?
Grateful.
But there is no any evidence the receipt date, my lord.
It is on affidavit. Have you challenged it?
Lordship, let them consider the representation annexure P2, my lord.
Well, since it is long.
This is not a representation, it's a reference under section
Reference, my
18.
lord. They have to
On the
refer it
basis
before
of that. Another instruction is necessary, my lord.
Let this be considered reference.
Yes, ma'am.
Yes,
Yes, my lord.
no instruction is necessary, Mr. Mondal.
Yes, my lord. After 2 years, my lord, there was a direction.
Unnecessary buying of time
Yes,
is not
ma'am.
permissible. Third learned counsels for the parties.
My lord, with only prayer, my lord, within a short period, my lord.
It is contended on behalf of the petitioner that upon acquisition of his land, comma, notice under section 12(2) of the Land Acquisition Act 1894 was issued upon him on 27th August 2012. Is that the date?
No, my lord, that is date on that,
Issued.
that was issue. Yes, that is the date
27th
for issuance of
27th August
August
2012.
2012, my lord, at page 15, my lord.
And received by him on 11th September 2012. Stop. Being dissatisfied with the award made in his favor, comma, the petitioner filed an application under section 18 of the Act of 1894 before the LA Collector, South 24 Parganas on 18th October 2012, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the application at the earliest. Paragraph. It is submitted on behalf of the state respondents that the application under section 18 of the Act of 1894 was submitted beyond the statutory period of time. Statutory period of time. Stop. In reply, comma, the petitioner submits that though the notice under section 12 within bracket 2 of the Act of 1894 was issued upon him on 27th August 2012, comma, it was received by him only on 11th September 2012. Paragraph, be that as it may, comma, since the application under section 18 of the Act of 1894 is pending before the authority since 18th October 2012, comma, the concerned authority being the respondent number 2, being the second respondent, be directed to consider the said application within 7 days.
15 days.
Within 15 days from the date of communication of this order.
Respondent number 3, special land acquisition.
Respondent number 3.
Three.
3, my lord, will consider.
Third respondent.
Special land.
And transmit the same.
Collector, then 2.
And refer the same to the competent civil court for consideration.
Well, subject to correction, my lord, it should be the collector, my lord, respondent number 2, not 3, my lord. 2, collector, 2.
Collector,
2.
It should be 2.
Yes, that was my idea. Also.
Yes,
Not the
earlier.
special land acquisition. Yes, 2 coordinator. Second respondent.
And my lord, affidavit of service was not recorded, my lord. This is with me, my lord.
To the affidavit of service. Disposed of which actually.
Great.
Number 32.
Petitioner
Is the unauthorized construction,
Petitioner not there. None appears for the petitioner. No accommodation is sought. Let the matter appear under the same heading on 10th July.
Number 33.
Lordship, in item 33, I appear for the petitioners. I humbly pray that the matter be listed on the next monthly list. Because there are certain clarifications which are required from the client, but he is unavailable.
On prayer of the petitioner, let the matter appear under the same heading in the monthly list of July 2023.
Deeply obliged, my lord.
Number 34.
Petitioner? 34 it is.
The statement.
Petitioner, no one. None appears for the petitioners. Stop, no accommodation is sought. Let the matter, first day, no dismissal. Let the matter appear under the same heading on 10th July.
Number 35.
I am for the petitioner.
Respondents?
The private is, I have had the. Mr. Soumitra Bandyopadhyay is appearing in this matter. Lordship. I have to file the evidence.
First, I have to first. Have you served?
Yes, Lordship, I have served. Lordship, the private respondent.
Mr. Dey, may I request you to serve? Please serve a copy of the written.
Yes, Lordship, I have to serve, Lordship. The private respondent are creating, constructing illegal construction on Kochuberia and Gangasagar Metal Road, Lordship, thereby obstructing the ingress and egress of the petitioner. Representation was made before the respondent authorities, but the illegal obstruction yet not be removed, Lordship. At page 14, page 2, representation was made, Lordship. The illegal construction to be removed from the
Highway Act.
Kochuberia and Gangasagar Road.
She Highway Act naki.
National Highway.
Let it be considered, Mr. Dey.
Yes, Lordship, and the illegal construction to be removed by the respondent authority.
They'll initiate proceedings. Affidavit of service. None appears for the respondents despite service. Private respondents are Mr. Dey regular school, copy service direction, paragraph. The petitioners claim to be the recorded owners of the plot in question and submit that the private respondents have raised illegal construction by encroaching upon a portion of the PWD road adjoining their plot, thereby obstructing their egress and ingress. Stop. The petitioners submitted a representation in this regard before the concerned authority on 25th February 2021, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the fourth respondent be directed to consider the representation in accordance with law. Paragraph in view of the above, the petitioner is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioner dated such and such petitioners. Within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, in accordance with law.
And Lordship, to remove the illegal construction in accordance with, if they are,
Section 10, madam, it has to be. There is no other option.
no, if any illegal construction is there, Lordship, that to be removed by the authority concerned?
That
Yes,
will-
Lordship, I have made the representation for removal of the.
Yes, so I've asked them to dispose it off. If they, upon demarcation, if they find there is an illegal obstruction, they'll initiate proceedings under section 10.
Yes, Lordship.
There is no other option.
Yes, Lordship.
এখানে তাই বলা আছে সেই জন্য ওটা বলতাম এখানে তাই
দিয়ে দিয়েছি।
যেটা কপিটা দিয়ে দিই।
দুটো copy আছে।
আজকে দিয়ে দিই হ্যাঁ এটাতে আছে
নামটা দিয়ে দিয়েছো? হ্যাঁ, please have a copy to him.
Yes, Lordship.
Number 36.
Lord, I appear for the response number 2.
I am for the state response.
Petitioner,
Lordship previously directed the parties to file their report in the form of affidavit, and that has been done.
who is appearing for the petitioner? No one.
Now,
Saptarshi Datta is the advocate on record.
who আসেনি who আসছে
He is not coming.
None appears for the petitioner. No accommodation is sought. Let the matter appear under the same heading on 11th July.
11 July. Yes. 11 July আসতে বলো আসছে না কেন?
Next,
Number 37.
Appear for the respond numbers 5 and 6.
petitioner,
I am for
yes.
Sanction.
Mr. Mondal for the state? State?
Lordship.
Last order. 18/4/2023.
Yes, lapse deposit.
Yes.
So what has happened after that?
And the state is to
Actually, there is no any scope, at this stage, state already deposited the amount before the learned district judge court. After long period, my lord, question is raised and came before your lordships, my lord. So at this stage, there is no any latches on the part of the land acquisition.
There is no question of latches. The deposit has lapsed.
So the petitioner.
So a
came-
special sanction is
petitioner-
required.
Lordship, it is true, my lord, but petitioner may pray before the district judge.
no, district judge.
Yes.
District judge has no authority
District
to.
judge already, that amount already sent to the account general office.
So the state has to give a sanction. This was discussed on the earlier date in detail, sir. You are repeating the same submission today again.
Now
And a detailed order has also been passed.
the amount has been credited to the consolidated fund of the state.
Yes.
My lord, it cannot be that it is with the accountant general. Accountant general is a part of the comptroller and auditor general. They are no way in connection with, my lord,
I am
holding the.
afraid Mr. Mondal has not taken the instructions. Yes.
Actually, earlier order is
Lordship,
very clear.
Several dates are being taken for this reason only. The same submission, same repetition.
Lordship, this is the technical problem is this.
This is no
Land
technical
acquisition
problem
collector
at all.
said that in pursuance of the court's order, already that award amount already deposited before the.
Have you seen the last order of the court where you have been directed to accord special sanction? So this will be a contempt. Yes. Have you seen the last order?
Lordship, kindly direct the district magistrate, my lord.
District magistrate will not do anything here.
My lord, collector. District collector. It will be the sanction granted by the finance secretary. State of. Finance secretary. Finance. We have written to the Secretary
The
Judicial
entire
Department.
matter is waiting only for your special sanction. That's all. Where is this letter dated 3rd January 2023? At page?
No, this I had handed over.
Lordship, the
It's not
finance
part of the
secretary
record?
is the
No, it's not part of the record. I had handed over, my lord. It will be.
So it must be
Yes,
here.
ma'am. Everything.
Yes, 3rd January 2023.
Oh. আবার আমাকে এখন জেরক্স করতে হবে, এখন পারবো না, পরে দিয়ে দেবো।
এক নম্বর কি ডিরেকশনটা নাও আবার সেক্রেটারিকে করো, নাহলে আমাদের পক্ষে সম্ভব না। ডিরেকশনটা কুড়িয়ে নাও। হ্যাঁ, ও বলবে ফাইন্যান্স সেক্রেটারিকে লিখবে, ওইটা কুড়িয়ে নাও, আমার কোনো আপত্তি নেই।
The district judge has made several requests which you have not acceded to.
My lord, data collector, they brought to sanction the finance secretary. Then finance secretary will, may I pray one thing? Finance secretary will not really, lease is very little. Your lordship kindly direct the respondent number 1 to comply your lordship's order dated 18/4/2023 within the specified date, and let report be submitted to your lordship.
Well, let it be to the finance secretary of the state, because ultimately he will be giving the post facto sanction. Huh?
Finance secretary.
তাতে কি হলো, স্টেট অফ ওয়েস্ট বেঙ্গল পার্টি আছে, তাতে স্টেট অফ ওয়েস্ট বেঙ্গল পার্টি আছে, তো কি হয়েছে, হাজারটা পার্টি করবে না কি? এলএ কালেক্টর অলরেডি টাকা দিয়ে দিয়েছে স্টেট গভর্নমেন্টকে, ওটা কনসিলিডেটেড ফান্ড অফ দ্য স্টেটে গেছে, কনসিলিডেটেড ফান্ডের থেকে বার করতে হলে পরে
ফাইন্যান্স সেক্রেটারি
দিতে পারবো না, ফাইন্যান্স সেক্রেটারি
অ্যাপ্রুভাল
স্পেশাল স্যাংশন। Special sanction. কি রিপোর্ট দেবে? আরে ফাইন্যান্স সেক্রেটারি আমরা চিঠি
The
দিচ্ছি,
district judge has made applications. District judge has made the application for revival of the
Yes,
tax deposit. That is sufficient. It was lying with the district judge, it has lapsed, it has gone back to the government, the district judge has asked for refund for realization of that amount. Now the government has to take steps. First respondent is the Secretary, Land and Land Utilization Department.
they are not the competent authority
No,
for, my lord.
absolutely not.
It is the finance secretary which is the competent authority, my lord, for giving the sanction. Because it's the amount has lapsed, the, my lord, consolidated fund, it to take out the money from the consolidated fund of the state, it will be the finance secretary.
So I don't think a change in the order is necessary.
No,
at
my
all.
lord, there is no need for
Whatever
change.
is, please comply with this order, otherwise you come up in contempt. Have to take necessary stringent steps. Please comply
Also,
with the
we-
18th April order.
Indulgence, my lord. Lordship kindly directs the LA collector.
LA collector has no
Or-
role to play here, sir. Please do not repeat
or
your
district
submissions.
judge to issue a notice.
District judge has issued several notices. Have you gone through this letter that has been given to you? No. Have you taken necessary instructions? No.
Lordship kindly added as a party the finance secretary.
It is not in dispute that the order passed on 18th April 2023 has not been complied with by the state respondents.
Finance secretary,
Paragraph, the state respondents are
state of West Bengal.
again directed to comply with the said order
ডিপার্টমেন্টের জন্য স্টেট
positively by
কি আপনারা শুরু করেছেন।
end of this month. 30th June, sufficient time. Otherwise, please take necessary steps. 30th June 2023. Paragraph, the direction may be treated as mandatory and peremptory.
Okay.
Let the matter appear under the same heading on same date. Same date করবেন আর একটু পরে দিন। Let it appear on 4th July.
4th July.
4th July. Compliance within 30th.
আর তোমার মুখ্যমন্ত্রী ওখানে গিয়ে একটু প্রসিড করা
Certificate copy. না দিন, আজকে না।
আলাদা করে একটা চিঠি
দাদা
Group 7 application, item number 979.
My application for restoration, Your Lordship.
Have you served?
Yes, my lord. Lordship, the affidavit of service.
Content matter.
Restoration. Restoration.
979.
Within time? Within time?
Yes, my lord. The order was
March
passed on
5th,
14th of March.
5th April, right?
The application, Your Lordship, was filed on
5th April. Right?
5th of April.
Affidavit of service.
Restoration.
Can,
for
no?
Group 7.
Can 4 of trading.
Group 7.
This is an application for. Why 2 applications? It 4.
It's Can 4 of 2023.
There are 2 applications.
The application
No,
concerning
affidavit of competency. Yes. This is an application for. This is an application for restoration of the writ petition which was dismissed for default by an order passed on March 14, 2023. Paragraph, sufficient grounds being made out, comma, the application is allowed. Paragraph, the order passed on March 14, 2023 is set aside. Paragraph, the repetition being WPA such and such is restored to its original file and number. Paragraph, can such and such is disposed of. Paragraph. No, WPA third. Please serve afresh. Let the matter appear under the heading Group 7 motion.
pleadings are complete, my lord.
Is it at the motion stage or the hearing?
Oh, my lord, it's at the hearing stage.
Hearing matter.
Pleadings are complete.
Let the matter appear under the heading Group 7 hearing on 7 July.
Lordship, I'll again serve afresh the writ petition along with the
Please
pleadings.
serve a notice.
That's all.
Bashu, the petitioner is directed to serve notice upon the respondents intimating the adjourned date.
No. Number 980.
My lord, this is a fresh contempt application.
Appearing for the first time.
First time.
Serve and come back. The petitioner is, the applicant petitioner is directed to serve copy of the contempt application along with annexure thereto upon the alleged contemner and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 7 July.
Grateful.
Number 983.
My lord, 983 and 985, I am not pressing, my lord.
983 and 985.
985.
Learned,
My lordship, I am appearing from respondent number 6 and 7.
he is not present.
As
Give your
it
name.
is. Let my name.
Give your name, yes.
My lord, it's having some defects, so
Petitioner,
with the liberty to file afresh. If
Private.
it's having some defects, my lord. It's having some defects. So, my lord,
you are just not pressing it.
my lord, I am not moving this application. This was for the first time. So, my lord, I am not pressing on the ground of defects, my lord.
See, learned counsel for the petitioner.
My lord, I'm in person.
The petitioner appearing in person seeks not to proceed with the writ application on the ground of certain defects detected herein. Paragraph, in view of the above, the writ petition being WPS of such and such is dismissed for non-prosecution.
My lord, with the liberty to file afresh, so advised.
Paragraph, however, liberty is granted to the petitioner to file a fresh writ petition on the same cause of action.
Grateful, my lord.
Paragraph, there shall however be no order as to costs, urgent certified website copy.
My lord. My lord.
983 and 985.
My-
Same.
my- Great.
983 and 985, same one.
My lord, in this matter, I am for the state, my lord, in 985.
Give your name.
Led by Mr. Raman.
Lordship, let our name be recorded. Good.
This 984.
983, Lord, I appeared on behalf of this
Give your
state.
name. 984. Not today. I'll dismiss it tomorrow. First day, no dismissal. Not today. No, 96.
986.
Well, I am for the petition, my lord.
Respondents?
And I made a representation, my lord, for transfer of the record of the stage carriage permit to the, my lord, regional transport authority, not having major portion of the route. All other routes have been transferred. My lord, I made a representation, let the RTA Calcutta transfer those records of the permit to the RTA, no, not 24. Page 19, my lord, is the representation. Let them consider, my lord.
Transfer of record of the stage carriage.
Only.
So let this be considered. Affidavit of service. The primary
Respondent 2, my
prayer
lord.
of the petitioner is for disposal of a representation submitted by him before the Secretary, Regional Transport Authority, Kolkata region for region seeking transfer of record of stage carriage permits of the petitioner initially issued by the RTA Kolkata region to the RTA North 24 Parganas, submitted on 13th October 2022. Paragraph, it is submitted on behalf of the respondents. Who should be the authority? 5.
2, my lord.
Respondent number 2.
Yes, ma'am.
That the second respondent be directed to consider the representation at the earliest. Should the affidavit of service. Paragraph. The writ petition is accordingly disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month. Within 1 month from the date of communication of this order. Opportunity of hearing is not necessary. Order. Stop. Disposed of which action?
In other cases, they have already done.
Yes.
987.
My application on it.
State, you're appealing?
Yeah.
But the facts is that I'm a permanent permit holder. My route is from Mansukha to Howrah. And it is issued by the State Transport Authority West Bengal. Now, I made a prayer for curtailment of the said route. That is at page, your lordship will find at page 20. That is at page 21. But this 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 prayer made on 10th of October 2018. Now, my lord, the lordship only come to
This has not been considered.
no consider. No, my lord, that is. My lord, now, my lord. Let you do. No, my lord, your lordship kindly come to page 27.
Page?
27. Annexure P5.
Yes.
One of this prayer rejected. You will also will find that second paragraph. Your application by docket number so and so dated so and so is rejected as the assessment made by you for curtailment of route will fail to serve the service of the common people. And my lord, my only grounds is this. This has been rejected unilateral.
Not heard.
Not heard. And my lord, the application has to be considered by the board.
By the?
Board, State Transport Authority has to consider. My lord, it has been considered. My lord, your lordship will find this is not the communication itself. This is the decisions that was taken by the one RTO and
Assistant Director.
Assistant Director. If these 2 points are there only, let them reconsider upon giving an opportunity of hearing to.
Let us hear the state.
No.
Yes, ma'am.
Yes,
Consideration of the
let it be
upon
reconsidered.
giving hearing.
So you admit that they were not heard.
No, actually, they are hard, my lord. My instruction is. Instruction is
So
not
why are
clear.
you asking for a
Instruction
reconsideration?
is not clear, my lord. Then I have to take instruction, my lord.
If they are not heard, an order can be passed. If you say that opportunity of hearing was given, then a different order will be passed.
My lord, then I have to take instruction, proper
My lord,
instruction.
then my lord, they have to produce only one thing. This is my pleadings that no notice of hearing was given, no hearing was given. First of all, the notice, and second, my lord, the date must be there, and to my lord, hear it out. But my lord, nothing. If they say I have heard, I've given the opportunity,
They have
then
to
there must be a notice.
They have to produce documents, yes.
My lord, then I have to
Either
file.
a hearing is done or they have not appeared despite receipt of notice.
Hearing.
If you
No,
are also
hearing done.
asking for
No
reconsideration,
hearing, no
in
hearing.
that case, you are admitting that they were not heard,
Actually, my lord, I have to, then I have to take instruction, my lord.
isn't it?
Yes, my lord, I have to take
This is
instruction.
Record your submission also that you are asking for a reconsideration.
Proper instruction, my lord. Upon proper instruction.
Let him come back. Please let him come back with instructions.
Instruction.
Because if I record his submission, that amounts to admission.
Yes, ma'am.
Let us not put the state into trouble.
Yes. Let them, my lord.
The affidavit says, the petitioner's grievance is that his representation made before the concerned authority on 10th October 2018 for curtailment of route Monsukha to Howrah between Monsukha and Borda Chowkan, BORDA CHOWKAN, আলাদা আলাদা শব্দ কিন্তু, was rejected without an opportunity of hearing being afforded to the petitioner. Paragraph, learned counsel for the respondents seeks to take instructions in this regard. Paragraph, let the matter appear under the same heading on 30th June.
Yes.
মানে তো সেটা তো হয় না
988.
May I মানে indulge my lord, I ought not have to my lord mentioned now when the last 19th a matter was there. This matter is not appearing in the even monthlies. Your lordship was not sitting at that.
Mention tomorrow.
My.
I'll consider.
My.
Nine 88, yes.
In this matter, my lord, after the petition is prepared, there is a subsequent development, my lord. The government of West Bengal has withdrawn that notification which is under challenge. Now, this is the notification, madam.
Well, if the notification which is challenged for your lordship, if it is taken up for consideration.
So nothing
then
further
Malad,
remains.
Now nothing remains. Then
Nothing
Malad,
remains.
my submission would have been that he has no locus standi.
No,
But
locus
not
standi,
a- not a- Malad,
because of my challenge.
Malad, not a single averment that how he is prejudiced.
No, because of my challenge.
Now
It's a
he is withdrawing very good, my lord, but.
It's a constitutional issue.
Constitutional issue, it is not a appeal. It is not a public interest issue.
However, you have superseded.
In any event, today, if my land.
Malad, kindly come to last paragraph, my lord.
If my
Last
land
but
wants
one
to
paragraph.
withdraw this, then
This
it has
issue-
become
This
infectuous.
is issued.
I have nothing to say.
This is issued in supersession of the department's order number 1643 WT such and such, and in partial modification of the department number 777 dated 1st of March 2023.
So it has not been rescinded, it has
But
been
it-
partially modified.
Modified.
But that serves your purpose.
That's I have to challenge again.
Whatever it may be, but my lord,
I have to challenge again.
now he wants to withdraw this.
No, withdraw কেন করবো? আশ্চর্য কি বলো বুঝলে?
He doesn't want to withdraw, it becomes redundant. The impugned order number 777 hyphen তার আগে affidavit of service name hyphen WT slash TPT slash 2/2021 dated 1st March 2023 issued by the Secretary, Transport Department, Government of West Bengal is under challenge in the writ petition. Paragraph, it is submitted on behalf of the petitioner that during pendency of the writ petition, the said order has been partially modified by an order being number 2085-WT slash TPT slash 2/2021 dated 2nd June 2023 and as such, nothing further remains to be adjudicated in the present writ petition. Paragraph, in view of the above, the writ petition being WPA such and such is disposed of. Paragraph, urgent certified website.
My lord, only thing, my lord, the point of locus standi raised by the state respondent, there is nothing to go into at the present moment. Otherwise, my lord, in the next round, if he challenge this, he may say that since earlier, my lord, in the writ petition, I have not taken that point regarding locus standi.
Is it necessary?
Lordship,
That
kind.
point is always open.
Lordship, kind.
I have a right to challenge.
No, I only.
You
no,
have a
no,
right to, you have to take
I do
objection.
not know why he is raising this type of objection. What I say.
Mr.
before
Sen,
the
that is not necessary in this writ petition
Not necessary.
Madam, may I,
because it is not being challenged at all now.
Madam, may I tell? My lord, the matter has been filed before your lordship. It's a fact. And the next fact is that because of the subsequent order, thereby modifying the earlier order, this writ petition has become infectious. It has, my lord, recorded therein. Only thing what I pray before the lordship that what I, my lord, want to say before the lordship is that the state respondent's contention that the petitioner has no locus standi is not gone into at this present moment.
Not necessary, Mr. Sen. When the matter is no longer under challenge, the question of locus standi doesn't arise at all.
I think my lord, my honorable will take this point
I
on
don't
the
know,
next
not-
time.
May
That
not
I have
come,
not
I may
taken-
not come.
Question, there is no question.
He might have
Next
suited my purpose.
Right.
No, may I take back the notification or your lordship?
You can take it back. Notification টা ফেরত দিয়ে দিন, শান্তনু।
Oh, notification, what is it?
989.
I appear for the petitioner, my lord. Lord, I have served everyone, my lord. Only against the private respondent, my lord, I have served on the address, my lord, they have, my lord, entered into the contract. Now, my lord, it has returned the remarks, my lord, the address is moved.
To find out the next
My lord,
address.
that is the contract I have challenged. That is the address. I do
Address
not
you
know.
Cannot be sufficient service.
True, but my lord, that is the railway has to provide it because it is the railway's contract. I have served on the address mentioned in their contract. If they have
You
moved,
can unofficially request your learned friend. I cannot give a direction.
Yes,
Lord,
The
unofficially,
railway is
but
under
I shall
no-
try my level best to
so
contact
far
with
as
them
my lord,
and so
my
that-
claim is based on against the railway, my
or
lord.
going for substituted service in that case.
My lord,
If you do not find the address.
because it's a continuing contract, my lord.
Why don't you speak to your learned friend and find out?
যদি পেয়ে যায় 100% দিয়ে দেবো আমি মকলের সঙ্গে কথা বলে
Because we have also tried, my lord, unofficially, but it's see though he is continuing with the Alta contract in the same address, but it's not, he's not there. It's all the contract. But my case is, my lord, I have challenged a tender process and, my lord, award of contract by the respondent railway, my lord, in violation of, my lord, their own circular. I have been awarded a contract, my lord, where, my lord, the base price was, my lord, rupees 2,80,568. It is in respect of East Coast Express, my lord. I have given an offer of rupees, my lord, 2,19,500 rupees. My offer was accepted. I was given a contract. While I was running a contract, my lord, respondent, my lord, came out with another tender process. There are two VPs, my lord, in the same train in respect of the second VP. There, my lord, they kept, my lord, the best price as 2,06,100 rupees. And if the contract was awarded, my lord, at 2,06,100 itself. I am aggrieved, my lord, because I am paying a higher rate and they are paying a lower rate. My contention is that, my lord, their circular, my lord, which is circular number 11 of 2022. If your lordship take, my lord, page 36.
I think you have to serve and come back.
My lord, I have served, my lord.
You have not served, you have sent.
It has come back. That's the problem, my
So
lord.
you have to find out the next address or you have to go in for substituted service.
Lord, substitute.
There are other
Your
modes. of
lordship
service.
sees, my lord, the cost title address and page, my lord.
I would request the railways to help him out.
Yes, my lord, I shall.
I will not give any direction because the railway is not bound by any direction. But
Because the address is, my lord, same. If your lordship see the cost
if you
title and,
get
my
the
lord, the
change the address from the railways, please do
There
that.
may be a change. এটা তো কন্ট্রাক্ট তো বোধহয় কোম্পানি নাকি?
Affidavit of service. Since service upon the private respondent is not complete,
আমি একবার জেনে নিচ্ছি। যদি
let
পেয়ে
the
যাই
matter
তো
stand over till
এইটা এখানে কিসের জন্য আছে?
7 July. Sufficient.
My lord.
You can take all the necessary steps by then.
Yes, yes. I shall. But I shall also try my 990
Lord, affidavit of service. kept.
Take.
অনামিকা পঞ্চায়েত।
This 990
HON'BLE statement.
petitioner.
I am acting on government. 990. 990 হচ্ছে।
990. Petitioner, no one. None appears for the petitioner, no accommodation is sought. Let the matter appear under the same heading on 10th July.
Nine 91.
I'm appearing on behalf of the petitioner.
I am for the adjustment.
What is the simple matter, non-constitutional matter? I applied for grant of contract with respect to auto rickshaw, page number 13. With requisite fees, page number 14, 13 and 14. That has not been get
Why I mean to apply for
So I did write the authority to consider. the-
Application for permit, not dealt with.
Consideration of application for grant of contract with respect to auto rickshaw. I applied on serial number 4.
Page 13, my lord,
Page number 13, we applied for
2019, my lord, 2019, my lord.
Two stations.
It is not traceable, I think so. Well, lordship can direct my land and
No,
friend to produce the
requisite fees, page number 14.
along with the requisite fees kindly.
We just supplied the same.
He has already paid the fee.
Yes, yes, yes.
I
No, no, no.
supplied.
We shall supply the copy.
Yes,
of-
yes.
Otherwise, they cannot
Yes, yes,
find out again.
No, I supplied, but I shall communicate the order along with this liquidation.
My
Absolutely, absolutely.
deep problem.
The petitioner's grievance is that his application made before the concerned authority for grant of permit in respect of auto rickshaw. Auto rickshaw has not rickshaw on, what is the date of your application? 5th February. 5th February 2019 has not been considered as yet. Stop the petitioner prays for consideration of the application at the earliest. Consideration of the application by the authority at the earliest. Paragraph. It is submitted on behalf of the respondents that the second respondent be directed to consider the application in accordance with law. Paragraph in view of the above, the writ petition is disposed of, directing the second respondent to consider and dispose of the application submitted by the petitioner dated such and such within 1 month,
6 weeks, my lord.
within 6
Court
weeks from
meeting,
the
my lord.
date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Within a week there. Within a week there, communication, my lord.
Yes, within a week thereof. Affidavit of service. Next,
Next matter same.
Similar matter. 992.
Same. Root, algebra. Root is also.
fine.
Order of mention question.
The application is at page,
Yes, page number 13.
page number,
13.
date
And
is same.
requisite fees, page number 14.
আচ্ছা, ওখানে যেখানে submitted application along with requisite fees. Along with requisite fees. The application. Along with requisite fees. For it of 5th February 2019. Same route. Same order in the next matter also.
Deep double.
There's one more matter.
Next matter also same.
993.
993, you're okay?
Yes. Page number 14.
Same matter?
Same.
Fine.
Page number 13 and 14.
Application date is same?
Date also same order. Date of application same. 5th February 2019.
February 2019. Same. These are all auto rickshaws. Same order. Within 6 weeks. Next.
994.
The petition. The petition is the register of a goods carriage. Registered to the registering authority of Howrah. The vehicle made an accident in Kamrup in Assam. Therefore, the vehicle was handed over to my client. Subsequently, it appears to my client the vehicle has been blacklisted by the registering authority of Howrah.
Who is
Without
appealing for the
hearing,
respondent?
without notice,
Sir?
without notice, without an opportunity hearing, it has been done. I have not been communicated him whether the vehicle has been blacklisted or not. But I have been come to know the vehicle has been blacklisted. For that reason, neither the tax, nor the CF, nor the registered permit. I cannot have the permit was valid on 7th of April 2023 national permit. I cannot even apply for renewal of my permit also. Well, that is the reason for I have to come before also, my lord. Well, blacklisting itself, my lord, without notice, without opportunity hearing, has been deprecated by the Supreme Court. Number of times, my lord. I have brought those judgments, my lord.
Let us hear the state.
My lord, you will kindly hear them.
My lord, it's a fact maybe that, my lord, the blacklisting what is done in the present matter, my lord, without any intimation. But the, my lord, there is a, my lord, guideline issued by, my lord, from the Ministry of Road Transport and Highways. Now, my lord, as per guideline, there are certain circumstances under instances when, my lord, the
registering authority, a particular registering authority, where the vehicle is registered. They can make it, the blacklist. There are certain, now one of the ground. One of the ground is that, if your lordship kindly have a look, there is, this is the latest guideline or instruction. Now, I leave it to your lordship whether that has been, that particular circumstances occurred or not, or there is instruction to that extent or not. Now, so kindly come, but this is the the guideline dated 3rd April 2023. And the annexure 1, kindly come to serial number Adichi, serial number 7.
But Mr. Sen, where does it say that the owner of the vehicle need not be heard?
No, that has not been said. Now, what was the reason for this? If your lordship, kindly have a look. This is the communication from SBI General. I have not yet handed over to your lordship, This is with me right now, We received this communication.
Will you come back on affidavit?
For the time being, if your lordship kindly have a look.
He has to go through the documents.
Oh, yes.
Otherwise, it will not help.
Yes. Now, SBI General, the insurance company, they informed us that in a motor accident claim case, a degree or award was passed against the insurance corporation. Because the vehicle which met with the accident, the vehicle was insured with this SBI General. Now, the order or award was passed against the SBI General that initially they have to comply with the award amount and they have to disburse the same to the victim's family. But later there is a the liberty to get refund of the same or adjust the same from the the owner of the insured vehicle. The petitioner is the owner of that particular vehicle. Now, they informed us that since that dispute and or matter is pending, so take steps so that the vehicle cannot be the subject matter of any further transaction. That means handover, change of ownership. So, and in consonance with the the guidelines, where it appears, clause number 7, clause number 8 specifically mention court case that under these circumstances, total 9 circumstances mentioned therein. So for clause number 8, the court cases mentioned therein. So following this guideline, this blacklisting was made.
The blacklisting itself is illegal without hearing. I have got 3 judgments of the Supreme Court.
That's why I was suggesting that if you can come back with a report annexing these documents, because Mr. Samant has to deal with these documents.
I cannot,
Say court case.
Yes.
So those documents need to be placed before the court on affidavit. And please show where it is stated that blacklisting can be done under certain circumstances, even without informing the registered owner.
No, I cannot. I think there is, but it can be done in case of any emergency.
You are asking for you're talking about some exceptional circumstance. So that should be brought on record.
No, yes.
There should be some guidelines, some circular to it.
Yes.
Otherwise, it will be considered only on this ground itself. Has to be set aside. Let him come back with the report. You can take this back.
And one thing may I, though it is, I can suggest it, that SBI General, since they have written us this, the letter, because he cannot deny that the SBI General Insurance Company, that is the insurer.
No, the accident, the insurer, these are all admitted facts.
Yes.
But you have blacklisted.
No, since we have acted upon on the basis of this letter issued by SBI General. So if a lordship think it whether they can be added as a party hearing or not.
Necessary. If you have not heard the petitioner, nothing else is necessary. Or you have to show me the exceptional circumstances under which you can issue an order of blacklisting even without hearing the
I
petition.
do not think there was such an exceptional circumstance. I do not think. I think on the basis of this letter,
Only on that ground, this has to be allowed, the writ petition. His primary prayer is for setting aside the order of blacklisting. That's why I want these documents to be on record. The basis on which you have done this. Affidavit of service. The petitioner alleges that his vehicle being a vehicle bearing registration number WB 11C 4078 has been blacklisted by the respondent authorities without giving him an opportunity of hearing.
Without notice and hearing, without giving prior notice or hearing.
An opportunity of hearing. Paragraph, learned counsel for the respondents seeks to submit a report in the form of affidavit in this regard, annexing relevant documents. Paragraph, let the matter appear under the same heading on 4th July.
4th July, but a report in the form of affidavit.
Yes, right.
Affidavit of service.
Of 7th July.
995. This matter will appear for the petitioner. If the substitute.
Yes.
The respondent number 7, I have served the respondent number 7, but the respondent number 7 is the permit holder in respect of the route.
Who is appearing for respondent number 7?
He has been served. He has been served. It has been received by him. The respondent number 7 was the register, was the owner of, was the permit holder in respect of the route lot. In respect of the route lot, Krishnanagar to Nadia. They will also will come to page 12, annexure P2, annexure P1.
Yes.
Sir Milan Chandra Ghosh was the holder of a permit in respect of the Krishnanagar to Badwan, and the permit was remained valid from 18 February 2002 to 17 February 2027. Now the vehicle attached to the permit has completed the age of 15 years in the year 2020. He could not replace the vehicle. Therefore, on the basis of the joint application made by the respondent number 7 and the petitioner, the permit to transferred in the name of the petitioner. Page 14. And page 14 is the order of the state transport authorities. The undersigned is directed to inform you that the hearing in connection with the transfer of permit bearing number so and so was conducted on 30/11/2022 in the chamber of the Secretary, State Transport Authority, West Bengal. And the Secretary STA has allowed transfer of permit from Milan Chandra Ghosh to Dipendu Shah from the respondent number 7 to in the name of the petitioner petitioner. It has been transferred. But on the basis of this transfer effected in the name of the petitioner, I applied for replacement of the her model vehicle in place of the attached vehicle, which has completed the age of 15 years in 2020. I made the application page 15 with the her model vehicle. With the her model vehicle for replacement for operation of the vehicle on the permit which remained valid till 2017. That prayer has not been allowed by the authorities. They simply said that it could not be done. In terms of the latest order I have annexed in the petition, page starts from page 24.
the latest notification based on the earlier notification. On page 24, you also kindly see, 1st March 2023. Annexure P6
At page,
at page 24. Page 6, blood. Annexure P6.
page, yes.
Page 24, blood. This
The
is the latest
guidelines,
notification,
yes.
1st March 2023. Now your lordship will kindly come to the relevant part of the said notification, page 27. Page 27,
Yes.
C. Category number C, replacement of vehicle should be encouraged to be made by higher model vehicle or at least by similar technical specification, including BS norms of the existing vehicle in compliance with the order in terms of Rule 153 of the West Bengal Motor Vehicles Rules.
Your application has not been considered.
Has not yet been approved by the authorities. They simply said that it cannot be done.
Where is that order?
That order has not been
Communicated.
that order has not been made by in a written form, only simply saying that it cannot be done. When after submitting the application with the fees, he paid a visit that it cannot be done. On that basis, my lord, I am moving this application that in the prevailing notification there is no bar to replace a higher model vehicle. But I wanted to replace a higher model vehicle. That has not been allowed by the authorities. And my lord, I have supported by decision of this bench, my lord, I have annexed the order that I placed a BS3 model vehicle, which was earlier is a BS1 model, but I placed BS3 model, which has not been allowed. Therefore, my humble submission, my prayer for replacement may be allowed by the authorities by taking appropriate decision in the matter. My lord.
Let us hear the authority. Yes, Mr. Debra, you are appearing in this matter.
I am relying on the notification of 1st March 2023.
My specific submission, my lord. The vehicle has already been transferred in the name of the petitioner by the STA board
Yes.
regarding permit is concerned. Regarding registration is, my lord, registration, they have not complied with the full formalities. Lordship kindly see my instruction paragraph C also. Incorrect.
Transfer of ownership of the vehicle has not been done. That is your case.
That is his case.
That is not my case. My permit was transferred in my name from the name of the
Registration of the vehicle has to be transferred.
has completed the age of 15 years in 2020.
Right.
The owner could not replace the vehicle by way of making a
He
joint
wants to
application.
place a higher model vehicle.
Well, after transfer, I want to place a higher model vehicle. There is no bar in the statute and neither in the
Lordship kindly see, my lord, 122 rule 122 of the Bengal rules. West Bengal rules. 120
rule.
122.
of the Bengal rules, my lord, West Bengal rules. Motor vehicles rules. Entry of registration, mark 1 permit.
Yes.
So you say that the registration of the new vehicle has not been placed before the
But
authority.
page 16,
That is the
the
main. thing.
registration mark stands in my name of the vehicle, of the higher model vehicle. Well, that
is
rule
not produced.
122 of the rule does not apply in my case. 153, page 16. is the registration certificate of the vehicle stands in my name. That is the higher model vehicle.
Page 16.
Bendu Shah.
Yes.
Vehicle stands in my name. It is a higher model vehicle. I want to replace it. What is the bar? 153 specifically says why a hard model or no, it is similar nature of vehicle.
It is transfer order. Yes, allowed is transfer.
Page 16.
Page 14.
16. 16.
আমার গাড়িটা বেশি 80 বুকটা। Page 16. It stands in my name.
It is in his name.
That this vehicle is to be replaced on the permit.
কিছু দিয়েছিস?
Page 16. এটা কি হয়েছে?
So this is the transfer of ownership in his name.
I do not know, my lord.
Your instructions are not correct.
Already they have name has been transferred. What is this? I take further instruction, my lord. That is better.
The vehicle stands in my name.
No, what?
Let them take a objective decision on my prayer. Let them take
That can
objective
be, that
decision
can be lost.
upon giving hearing and
Giving you. So
after scrutiny of all documents.
কাগজপত্র জমা দিয়েছিস?
সব জমা দিয়ে আছে।
কোথায় আছে বল?
ওই তো এই যে দেওয়া আছে। এই যে page হচ্ছে এটা,
Page?
page 15.
15-তে?
Page 15.
Let page 15 be decided in terms of page 27.
My lord.
In terms of the permission granted by them, in the light
terms
of the,
page 27, yes.
in the light of the notification dated, page 24.
Yes, yes.
Page 15, my lord.
Squarely governed in my case, the replacement order.
আমি নিজেই ক্লিয়ার না। ওদের ইনস্ট্রাকশন আমি ক্লিয়ার।
Instruction তো বলে দিয়েছি। Instruction পরে
Affidavit of
কি দেখ
service.
না এই জায়গাটা কি বুঝলো আমি পারলাম না। না না এগুলো কি করে এটা ছেড়ে দে ট্রান্সফার দিয়ে
It is contended on behalf of the petitioner that the seventh respondent was the owner of the permit bearing number
judgment
22/2007 within bracket I/R bracket closed, I/R bracket closed, I/R টা bracket এ R হ্যাঁ in respect of vehicle bearing number WB 41B 7125 on the route Krishnanagar to Burdwan via Malomba MALAMBA, Kusumgram, Navadip, and the permit is valid up to 17th February 2027. The vehicle attached to the permit completed the age of 15 years in 2020 and due to incapability of the seventh respondent to replace the said vehicle by a higher model vehicle, the said respondent, along with the petitioner, submitted a joint application before the concerned authority seeking transfer of the permit in favor of the petitioner. Stop. The Secretary STA, the State Transport Authority, allowed the said transfer in favor of the petitioner and by a letter issued on 2nd December 2022, the RTO and Assistant Director, State Transport Authority, West Bengal, requested the Regional Transport Authority, Purbo Bardhaman, to take necessary action for transfer of ownership of the vehicle. Transfer of ownership of the vehicle. Stop. The petitioner submitted a representation before the Secretary, State Transport Authority, Kolkata,
It has to be RTA border.
No, no, no.
Permit,
this
replacement,
is Kolkata.
permit has been granted by the STA Kolkata, therefore replacement has to be made by the STA. Registration is a separate thing. It cannot be equated with the replacement of the vehicle.
Seeking replacement of the vehicle of higher model registered in the name of the petitioner. Representation date representation. The date of the representation is 7th February.
7th February.
On 7th February 2023, which is yet to be considered. The petitioner prays for consideration of the representation by the concerned authority at the earliest. Paragraph. Learned counsel for the petitioner takes this court to the guidelines issued by the Government of West Bengal Transport Department on 1st March 2023, which 23 comma clause B, capital B, small c of which B, C, capital B, small c, of which demonstrates that replacement of vehicle should be encouraged to be made by higher model vehicle or at least by similar technical specification, including BS norms / age of the existing vehicle, comma, in compliance to this order in terms of Rule 153 of the West Bengal Motor Vehicles Rules 1989, comma, subject to decision of the respective transport authority. Stop. Learned counsel submits that the vehicle intended to be placed, sought to be placed for replacement is of a higher model than the existing vehicle. Paragraph. It is submitted on behalf of the respondents. Who should be the authority? That the fourth. The fourth respondent be directed to consider the application made by the petitioner in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the fourth respondent to consider and dispose of the application submitted by the petitioner dated such and such in terms of the letter issued by the RTO and Assistant Director, State Transport Authority, West Bengal, to the Regional Transport Authority, Purbo Bardhaman, on 2nd December 2022, and in the light of the order made by the, in the light of the guidelines issued by the Government of West Bengal Transport Department on 1st March 2023, in the light of the guidelines, comma, issued by the particularly clause capital B within bracket small c thereof, comma, within 1 month, should be within 2 weeks.
Within 4 weeks, man.
Within 4 weeks, otherwise,
within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioner, comma, in accordance with law. Paragraph, the decision taken by the
private
authority
respondent also, my lord.
to the petitioner and the private respondent in accordance with law.
Hmm.
Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Right.
Disposed of which apply.
Hmm.
Mr. Debra, you can take back your instructions. It doesn't help you.
I failed to understand this language of the instruction.
In any event, rule 120 does not apply in this case.
And this is not correct also, the instructions. Next. Next.
We shall deal with it. কিছু থাকলে কি আছে দাও না না আমার কাছে কোনো কপি নেই দিতে পারবো দিছি এইটাই ট্রাবল যা হবে নিজেই দেখাবে আমরা আমাদের দেখতে দেবে তোমার
Yes, next matter, 996.
দেখাইনি তোমার মম না না দেখাও না থাকলে দেখাবে না কেন ইট ইজ ওপেন ফিল্ড এই কথা এই পরে কোনটা নব আই অ্যাপিয়ার ফর দ্য পিটিশন But an application has been made for grant of permit, page Lord 11.
For grant of?
For grant of stage carriage permit in respect of a route.
এখন কি আছে আমি আগে চোখে দেখিনি।
Pandua to Samudragad to Pandua, it is an inter-regional route. But with the application, it was submitted.
আসতেই চায় না, সে নাকি প্রচুর ব্যস্ত।
But the respondent placed the application in the RTA board meeting. It is an inter-regional permit, Lord. Major portion covers within the Bardhaman region. Therefore, as per section 69, there the appropriate authorities to take the decision regarding grant of permit. However, the authorities call for no objection from the other region. In the decision, they have taken the decision to call for no objection from the other region. Accordingly, letter was sent to the other region for sending no objection. But it is not known to me whether no objection has been sent by them or not. But the statute says when an inter-regional permit is issued by an authority having a major portion, after grant of such permit, it is required to be countersigned by the countersigning authority. That is the law.
Yes. Where is the provision for a no objection?
8 specifically says so. Now, rule 103 has been framed that for the purpose of granting inter-regional permit, now no objection is to be called for from the other region. However, the rule cannot prevail upon the statute. I am relying on section 69 and 88. My humble submission that let the authority take the decision regarding grant of permit irrespective of the fact whether no objection has received or not. But that is not mandatory. That is not required mandatorily for this case. But I am supported by decision of our High Court that even if the no objection is even if the no objection is obtained from other region, even then, after grant of permit, it is required to be countersigned for validation of the permit to the entire route. Therefore, it is an useless formalities for having the no objection from the other region for calling for no objection. Exactly on this point, now a decision has been made by our High Court in case of Ashim Kumar Ghosh versus State, and I find that in that case, Mr. Sen appeared for the state respondents and submitted his argument in the line which I have placed before your lordship. These are this. So excuse me, I have no Xerox copy. That's what তুমি citation টা বলো তো একটু ভলিউম কি Ashim Kumar Ghosh versus State 83 Your lordship kindly take the trouble of seeing the book today, Lord. It is my fault not for having the Xerox copy of the judgment.
Well, I have marked the relevant portion. একটু খরচা করতে পারো? এগুলো দেখবেন একটু ক্লার্ককে বলবেন এগুলো জেরক্স করে রাখতে। But only thing, Lord, whether the rule 103 can prevail upon the statute. It is immaterial whether no objection is given or not. After grant, it is required to be countersigned by the other agent for validation of the entire permit. তুমি তাই তো বলেছিলে। আমি কি বলেছিলাম সেটা বড় কথা, জজ কি বলেছে সেটা বড়। দেখো সেটা দেখো, এই কথাটাই বলেছি। সেটা বড় কথা, যেটা বলছি ওখানে কি বলেছে, জাজমেন্ট কি দিল সেটা তো আমি যেটা বলছি জাজমেন্ট তাই বলেছে।
The relevant paragraph is paragraph 24.
The only point for consider whether the no objection, whether given or not, after grant of such permit, it is required to be countersigned for violation of the permit to the entire rule. This is the law.
Both the provisions complement each other. They are not contradictory. The
But
judgment says so.
That might have been, my lord, my submission, but the court rejected that. Court said that both should prevail. So far I recollect.
Now the,
So far I
if the
recollect.
They are
both are
complementary.
prevail, then what would be the result and effect?
So have you obtained the no objection SSN?
My lord, may I tell, my lord? I think, my lord, not yet. My lord, it appears from the, my lord, annexure to the writ petition. People also kindly,
Last.
yes,
They sought for.
last annexure, page number 16. My lord, the permit issuing authority, my lord, sought for no objection from the other RTA. That is at page number 15.
This is before more than a year.
Yes,
Yes.
After that,
no development.
No, it is, yes,
15
22.
5th January 2022.
No. 5th
Over-
January 2023,
Or 5th January 2023. Yes.
23,
Then
That
6
too,
months.
6 months.
6 months. Now, my lord, may I tell, my lord? My lord, if you lordship, my lord, be kind enough to, my lord, dispose of this matter by directing the Secretary RTA Hooghly to respond to this letter of memo number 15 issued by RTA Puro Bardhaman within a specific period. And then, my lord, on the basis of that, my lord, the final consideration be made by the other RTA, that is the, my lord, the Regional Transport Authority Puro Bardhaman. Because, my lord, to some extent, my lord, so far RTA Puro Bardhaman, before whom the application has been made, in terms of Rule 103, sought for a confirmation or no objection. Now, my lord, whatever be the reason, I do not know right now, my lord, that the intimation has not yet been given or obtained, my lord, by the RTA Puro Bardhaman.
But in that line, it can be disposed of. In that line.
So,
They'll also
in
kindly
that light-
specify the time limit by which they have to respond, and the authority be directed to take the decision on the basis of that upon giving me hearing.
No, so far the Secretary RTA Hooghly is concerned, there is no need for any hearing.
I
No,
want hearing by the
RTA
Bardhaman
Puro
from the
Bardhaman
Bardhaman.
against,
And
before
now
whom,
he may or may not issue a no objection.
Yes.
So let it be considered. let this letter, the last annexure, be considered by the
Yes,
RTA,
yes,
by the Hooghly RTA,
by the Hooghly RTA.
and communicated to this RTA, upon which,
Yes.
upon receipt of which he will consider within a specified time period.
Fine.
Upon giving me hearing,
Let it be, yes, let it be
Yes.
1 month and 1 month.
yeah, my lord, so far the Hooghly is now 6 months has been, you also kindly direct them within 2 weeks, they said to respond to the letter, and they should take the decision by 4
Within
weeks.
2 weeks, I think, my lord, the board, because everything
Let
can
it
be
be
taken
1
up by
month
the
and 1
board.
month. Again,
By
it
the
will
board.
come back otherwise.
Very
Let
well.
it be 1 month and 1 month.
Very well.
You have waited for so long, please wait for
Yes.
some little more time.
And my lord, your lordship kindly direct the authorities to take the decision in the light of the prevailing, in the light of the existing statutory provisions. Let them take a decision in the light of the Motor Vehicles Act 69 and 88 of
They have to, there is no other option.
your lordship kindly
The
indicate,
statute
yes.
has to be followed. The court
Yes.
cannot give a direction for following statute.
Yes, yes, no, your lordship
That is
kindly
the
indicate,
statute
your lordship
itself.
kindly indicate so that I can ventilate my right over there
They-
about the position of the 88, section 88.
Do they, you will be given an opportunity of hearing.
Very well,
Do they have any other option?
very well.
Affidavit of service.
জন্যে তুমি এত
It is contended on behalf of the petitioner
মুখিটা
that
আছে না
the petitioner applied for issuance of stage carriage permit on the route Somudragad to Pandua via Kalna and Inchura, INCHURA, on 28th October 2022. Pursuant to which, pursuant to which the regional transport officer Purbo Bardhaman, by a letter issued in favor of the Secretary Regional Transport Officer Purbo Bardhaman. Secretary, Regional Transport Officer Purbo Bardhaman issued, কি বললাম তোমার? In favor of the Secretary Regional Transport Authority Hooghly on 5th January 2023 requested issuance of no objection certificate under Rule 103 of the West Bengal Motor Vehicles Rules 1989 in favor of the petitioner. Stop. Such no objection certificate is still pending. The petitioner prays for a direction upon the Regional Transport Authority Hooghly to issue no objection certificate in his favor and a direction upon the Regional Transport Authority Purbo Bardhaman to consider his application upon receipt of the no objection certificate within a stipulated time frame. Paragraph upon consideration of the submission made on behalf of the parties,
That is one number 2, my lord.
this petition is disposed of, directing the
Respondent number 2, my lord.
Hooghly is the fifth respondent.
Hooghly is the
First, fifth should be
Yes, yes,
sending,
yes.
isn't it?
First.
Directing the fifth respondent to consider the letter issued by the Secretary Regional Transport Officer, Regional Transport Authority Officer, or Authority Purbo Bardhaman on 5th January 2023 for issuance of no objection certificate the Regional Transport Authority Hooghly upon affording reasonable opportunity of hearing to the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of, which are.
Fine.
Authority. Mane na.
One of the only thing may I pray, Lordship, that at the time of my lord communication of my lord's order to the secretary RTA Hooghly, let him just indicate this memo number and the date of this.
Yes, certainly, I will.
The details have to be.
No, I will. It need not be.
He cannot be, he cannot trace out of it.
No, I
They
will.
cannot
While
trace out.
communicating, I must annex a copy of the same.
Enough, enough. Get
Next.
Next data.
Next,
Identical matter, next. Same matter. Same, similar correction may be issued. And later dated is also similar. And the decision is also similar. Same date. Same date. Well, the decision is at page 14.
This is also 5th January, yes.
Yes. 5th January.
So the same order may be passed.
Same order. Same order.
Respondent numbers 2 and 5.
Yes, 2 and 5. Yes.
Rajiv, same order. Please. Affidavit of service.
Yes. Thank you. Disposed of. 998.
As per instruction of the department, I am appearing on behalf of the BSNL.
The Lordship, I'm appearing on behalf of respondent number 5 and 6.
What about the petitioner?
Petitioner is a actual aspect. This, as per my contention, is this honorable court has no determination because it is a BSNL matter, service matter. The petitioner number, respondent number 5, as per notification dated 31st October 2008. BSNL, all the service matter relating to the service matter, the matter jurisdiction is honorable CAT. Factual aspect is respondent number 5 is the employee of BSNL. He superannuated. Subsequently, his retirement benefit is disbursed. Regarding the BSNL is not paid the entire benefit, it is paid by the service matter.
Yes, right.
The service matter.
I'll release the matter.
Huh?
I'll release the matter.
Service matter. This honorable court has, this high court has jurisdiction. নামটা দিয়ে যে কোর্টে হবে সে কোর্টে 998.
This should be dealt with by the Central Administrative Tribunal.
Yes, my lord. As I have the judgment, but no judgment is with my
That appears
mobile.
for the petitioner. Stop, no accommodation is sought. Paragraph, it is submitted on behalf of the respondents that the grievance of the petitioner in the writ petition is required to be dealt with by the Central Administrative Tribunal.
As
And
per
this-
notification dated 31st October 2008.
As per notification dated.
31st October 2000.
Notification of,
Notification of
notification issued by the.
Ministry of Personal and Public Grievance and Pensions. Department of Pension and DOPT.
Please write it down in a paper.
এটা লিখে দাও।
Issued by it on date and this court has no jurisdiction to deal with the same. Paragraph, in view of the above, comma, the writ petition being WPS such and such is dismissed due to lack of jurisdiction. Or dismissed as not maintainable. Dismissed as not maintainable. Urgent certified website copy.
I'm grateful for the Lordship.
Nine 999. I am here for state.
Petitioner? No one. None appears for the petitioner. No accommodation is sought. Let the matter appear under the same heading on 14 July.
Item number 1000.
My lord, I am for the petitioner. Mr. Shaktipada Jana will appear in this matter. He is not in town, your lordship. So I am praying for not this week.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 23rd June.
Grateful, your lordship. Namta di diচ্ছে।
Next.
Item number 1001.
In this matter, not I am appearing for the petitioner. Let it be taken up any day after next week, my lord, because I am to complete the service.
Since service upon the respondents is not complete, let the matter stand over till 23rd June.
23rd.
1002.
Respondents,
Only the state respondents.
who is appearing?
My lord, this matter, my lord, the petition I received, copy of the petition on the last day before the.
You need some time.
My lord, at least 2 days time.
Mr. Khan, some. On prayer of the affidavit of service. On prayer of the respondents, the matter is adjourned. Let the matter appear under the same heading on 26th June.
My.
We have 5 more minutes, so no use calling hearing matters. और आपने आंसर